Good afternoon and happy Valentine's Day. Welcome to the Ways and Means Bill hearings. Today is February 14th. To my awesome committee members, I put some little tchotchkes on your desk. If you're feeling a little stressed, just, relieve yourself, squeeze the stress ball, play with some slime, whatever you want to do. You can thank my kids for all the goodies. Yeah, I gave you the pink one.
But I wanted a pink.
Yeah, and I gave you pink and green, yeah. Okay. Calling House Bill 450. Delegate Lewis, come on up with whoever you'd like to bring with you. And whenever you are ready.
I'm bringing up a representative from SDOT who's only here for informational purposes. They're not taking a position on this much-needed bill. Chair Atterbury, Vice Chair Wilkins, and the glorious Committee of Ways and Means. Glorious. Good to see you guys again. I'm here in support of House Bill 450. This bill seeks to cap the municipal tax rate for business personal property tax to be no more than 2.5 times the average corporate property tax of the municipality's county and the county property tax rate for the real property combined. I'm gonna just lay it out. This issue is based off a big issue in my district, the city of Seat Pleasant. That's personal property tax is 12% per $100 of assessed value, which is way higher than anywhere else in the state. So this is a one-time you will see, yes, me, House Majority Whip, a Democrat, asking to lower taxes. We can all agree on that. But as a, the city's having a number of issues currently. There's a work group in the Senate that's reviewing Seat Pleasant specifically, particularly as it relates to some money that's gone missing. Part of the reason I'm bringing this bill is because as a assembly, we've dedicated $400 million to the Blue Line Corridor to help revitalize the area surrounding FedEx Field, which the people in my district, the people of Prince George's County greatly appreciate. Seat Pleasant has a significant portion of the Blue Line Corridor, and this insanely high personal property tax is dissuading the type of development that we want to see to revitalize this community. So it's absolutely necessary for us to pass something to lower it. The average personal property tax in the district, the county, is about $1.50 to about $2.25. 1.5% to about 2.25% per $100 of assessed value, not 12%. All right, it's just way, way higher, and we need to fix this. SDOT is here for any specific technical questions, and I urge a favorable vote on this bill. Thank you so much.
Thank you. Are there any questions for Delegate Lewis? Delegate Plakovich-Carr?
Thank you, Madam Chair. My question is actually for SDOT. Do we know, would other municipalities, is anyone else, would they be impacted at the threshold set in the bill?
Whether a municipality will be affected by this bill. This bill creates a cap that is so high that most municipalities can double, triple, quadruple, go up substantially more while still forcing Seat Pleasant to reduce their personal property rate.
Any other questions? I'm just curious, what is the historical perspective of how did it get to be 12%?
It's a great question.
If you know, I'm
Sure.
just...
So most jurisdictions use mainly property tax revenue and a little bit of business personal property tax revenue to fund their operations. The city of Seat Pleasant has wanted to use about half of their revenue coming from personal property taxes in addition to real property taxes. So it's just for example, of the 156 municipalities, only Seat Pleasant is above the 2.7% business personal property tax rate. So that's 400% higher than the next municipality.
The context, Madam Chair, is because at the time, they increased this personal property tax as a means to funding economic development initiatives, expanded services in the municipality. That's why, right? It is in a historic Black community, low-income community. They wanted to do more. Their heart was in the right place. The problem is it's driving away businesses that we need, and they haven't turned their audit to the state that they need in order to continue getting funds since, was it 2019, I believe?
Yeah, it's been 3 years.
So they're not being the best steward of the funds that we're giving them currently. So we need to rectify this.
And I also want to point out that I did alert committee staff, but we made a technical mistake when drafting the bill on page 2, line 21. It should say personal and not real. So that's page 2, line 21.
Thank you. Any further questions? Okay, seeing none. Thank you, Mr. Majority Whip. And
Have a
that-
great day. Happy
Thank
Valentine's.
you. Thank you. That concludes the testimony on House Bill 450. Delegate Charles is going to present House Bill 444 from Prince George's County.
Thank you, Madam Speaker. Ooh,
You just elevated me a little bit.
promotions.
Appreciate it.
Promotions. Madam Chair, to all of my colleagues of the House Ways and Means Committee, for the record, I am Delegate Nick Charles, Chairman of the Prince George's County House Delegation, here to speak on behalf of House Bill 444 and ask for a favorable report. This is a bill that was brought forward to our delegation by the county executive. This is a late file bill on our side, so we'll be having a hearing on Sunday at 4 o'clock for our community to come in and get engagement on this bill. But we're going to move forward with this bill as of right now. What this bill does is it authorizes our county to enter into a payment in lieu of taxes agreement with the owner of a real property that is used for low-income housing and that is financed through the county's right of refusal program and generally related to payment in lieu of taxes agreements for low-income housing. This is something, as we all know, the cost of housing is a very extreme and real issue that's impacting a lot of our jurisdictions. And so our county helped to create this pilot program in 2021 through House Bill 1010. Which authorized our county to enter into this agreement with owners specific to this. And it's been successful utilizing this 2021 program and law. And they want to expand the affordable housing, including the recently announced affordable housing project at the West Hyattsville Metro Station that will reserve half of the 293 new apartments for tenants with income that is 80% of the area median income. And so we want to make sure we give our county executive all of the tools to make sure that we're looking out for our constituents properly within Prince George's County. Once we're done with this hearing on Sunday, we'll more likely move with a favorable report, and the letter will be coming directly to Ways and Means Committee so we can move on this bill. For the record, I have Patrick Gallagher with the county execs team to answer any questions in terms of technical issues or questions you may have relating to this bill. Thank you.
Are there any questions from the committee? Okay, seeing none. Thank you, Delegate Charles. And that concludes the testimony on House Bill 444. Calling House Bill 457, Delegate Embry. Welcome to Ways and Means. And you have someone testifying virtually after you begin.
Thank you so much, Madam Chair, Madam Vice Chair, committee members. I'm very excited to be here. I'm Elizabeth Embry. I am here to introduce and describe House Bill 457, which clarifies the purchase money mortgage exemption in the recordation tax. The bill is designed to protect longstanding practice, longstanding interpretation, and also to preserve local revenue. As this committee knows, the state of Maryland imposes a recordation tax for certain written instruments, transfers of title, deeds of trust, et cetera, and also mortgages and other security debt instruments. And even though it's imposed under Maryland law, all of the revenue flows to the local jurisdictions. The law on its face has an exemption for what are called purchase money mortgages. A purchase money mortgage is essentially a mortgage that combines the purchase price of the property and the money that's being borrowed to renovate the property. So it's one recordation, one mortgage that covers both the purchase price and the construction price. And so the purpose of the exemption is so that a person who is buying a property and through this means is not double taxed for the purchase price, because you have to also pay a recordation tax for the deed for the purchase. So the goal is to avoid double taxation. The problem is that it's written very broadly to exempt the entire purchase money mortgage. The Maryland Attorney General's office, as early as 1939, explained that it is limited only to the purchase price. That clarification was reiterated in an advice letter in the 1990s. The courts have recognized it. However, in Baltimore City recently, may also be true across the state, lawyers have recently been arguing, because the language says the full purchase money mortgage is exempted, they're arguing that they should have to pay no recordation tax at all on the mortgage portion of a purchase money mortgage. And just as an example, let's say I'm buying a property for $100,000 and I want to put $150,000 in on construction and renovation. I would get one loan for that full $250,000. That's a purchase money mortgage. I will have to pay a separate recordation tax on the $100,000 purchase price, but I should not. But then I should have to pay a recordation tax on the $150,000 additional that's the mortgage. That, again, is current practice. This is just preserving current practice and preserving local revenue. This is a cross-file of Senate Bill 65, which was heard in Budget and Tax on January 19th. Deputy Solicitor Stephen Salisbury from the City Law Department, he is available. He can provide additional testimony and answer any questions you have. I see him there. And with that, I thank you very much and urge a favorable report on this bill.
Thank you. Are there any questions from the committee for Delegate Embry or Mr. Salisbury? Delegate Buckle.
Thank you, Madam Chair. So that's my understanding of how this generally works too, is that you attempt to divine out or separate out what I paid for the property,
Right.
which I've already paid the recordation tax on the deed, versus what I'm getting a loan that is secured by the property if I'm going to improve it or renovate it or do whatever. That's I think you've said that is the practice.
Correct.
To my understanding. So what the bill, would it be fair to say the bill is going to codify what we believe to be the AG's opinion and the way most clerks of the circuit court have interpreted it for decades now?
Yes, correct, exactly.
Okay. And do you have a problem? I don't know if you've had an opportunity to see it. MSBA put in a suggested amendment, and their language to me looks like, I mean, we're lawyers and we write all this stuff and it's kind of confusing. Their language looks really good. It even puts a more finer point on exactly what I think you're trying to do with the bill. So it really spells it out, the distinction between what you can impose the recordation tax on and what you can't. Do you have an opportunity to look at their stuff? Do you think that's fine if we would do it that way?
Thank you very much for the question. I saw it yesterday, and I've shared it with the City Law Department. It sounds like it's just the inverse. It's doing the same thing, but just flipping it. I just wanted a chance to have the Law Department and their real estate attorneys review it to make sure it does what I think. I agree with you. When I read it, I had the same reaction, but if I could just get their
It seems
feedback.
like they're doing the lawyer trick of they're adding
Yeah.
more words, which actually does clarify. They're not just using the phrase of art, purchase money,
Right.
which in your bill, it just says to the extent that it secures purchase money. They're saying that the purchase exceeds the purchase price of the property purchased. So anybody can quickly figure out what that is because you just look at the deed and the consideration.
No, thank you. Again, if I could just, I would like the chance to
Sure.
to confirm with the Law Department. We've had one conversation, but and unless Stephen has more to say, but I think, as you said, it sounds like it does exactly what the bill is intended to do.
Thank you very much.
Any other questions from the committee? Okay, seeing none. Thank you, Delegate Embry. That concludes the testimony on House Bill 457.
Thank you so much.
Yes. Okay, calling House Bill 417, Delegate Foley. And if there's anyone you want to bring up with you, you can go ahead.
Yes, if I could.
Yep.
Madam Chair, bring up my panel. Bring up my panel.
You have two folks that are signed up virtually.
Okay, thank you, Madam Chair, and thank you, members of the committee. For the record, I'm Delegate Linda Foley, and I'm here asking for support for HB 417. Democracy is alive and well here in Maryland with one glaring exception. That's why I'm urging you to support House Bill 417, which would allow Marylanders to vote on a constitutional amendment changing the way we fill legislative vacancies that occur during the 4-year term of office. Currently, when a vacancy occurs in the General Assembly due to the death, resignation, expulsion, or other disqualifying event, the voters of a district have no say, virtually no say, in who replaces a departing legislator, no matter how much of the incumbent's term remains to be served. Under current constitutional language, the Central Committee of the departing legislator's political party recommends a replacement to the governor, who appoints the delegate or senator for the remainder of the unfulfilled term, whether it be 6 months, 2 years, or in some cases, a full 4 years. This constitutional amendment would inject more democracy and voter engagement in the process. The amendment, if approved by the voters, would require a delegate or senator appointed to fill a vacancy occurring more than 2 years before the end of a legislative term to stand for election. A special election would be held at the same time as the primary and general elections in the presidential election year. The state would not incur additional costs since a special election would occur during a regularly scheduled primary and general vote. And you can see that reflected in the fiscal note on this bill. Let me stress that this legislation would continue the current appointment process. Because of the nature of Maryland's 90-day annual General Assembly session, special elections are neither possible nor desirable in many cases. By maintaining the current appointment process, this legislation ensures that no district is unrepresented or underrepresented during any legislative session. Now, let me address some other concerns that have been raised. In the past, appointments have opened up opportunities for candidates who otherwise would not have been able to conduct full-scale campaigns in order to serve in the legislature. Particularly in my home county, Montgomery County, the appointment process has made our delegation more diverse over the years. However, in recent years, my research, which is attached to my written testimony, has shown that in the General Assembly as a whole, the appointment process has not produced significantly more diversity than results produced by elections. Besides, as I have already stated, this legislation would maintain the appointment process, thus giving appointed delegates and senators the advantage of incumbency when or if they have to run for election in the middle of the term. Another concern is the ability of appointed legislators to raise money in order to conduct effective campaigns in the middle of a legislative term. As we know, legislators are prohibited from raising campaign donations while the General Assembly is in session. The proposed legislation allows for a special election only if the vacancy occurs 55 days or more before the candidacy filing deadline for the presidential election. Legislators appointed to vacancies that occur after that date would not be required to stand for election until the end of the 4-year term. This should give appointed legislators ample time to raise campaign contribution before the session starts. I myself was appointed in December 2021 to serve the remainder of a resigning delegate's term. I had a little more than a month to raise money for a primary election challenge, a stiff primary election challenge in 2022. Despite the short time frame, the incumbency and experience I gained from serving one 90-day session and the fundraising I was able to undertake before the legislative session began were enough for me to head off a very competitive primary election challenge and conduct a successful election campaign in 2022. Prior to my appointment, I was chair of the Montgomery County Democratic Central Committee. The current appointment process, I can tell you, is very stressful and can create ill will towards Central Committee members who are doing their best to fulfill their constitutional duties. A requirement that legislators appointed less than 2 years into a 4-year term stand for election will help relieve some of that pressure on these volunteer Central Committee members. For all these reasons, I urge you to support HB 417. I thank you very much for your time and attention, and I'll be happy to answer any questions.
Thank you, ma'am. Go ahead.
Hi, can you hear me? Hi, thank you for giving me this opportunity to testify on behalf of Montgomery County Women's Democrat Club. My name is Lisa Smith, and WDC is one of the largest and most active Democratic club in our state, with hundreds of members. And we recently established a new committee, Advancing Democracy in Maryland. We are proud that Maryland is at the forefront of pro-democracy reform, yet we always can do better, and that's the reason why I'm here today. And let me give you a little fun fact about myself. I'm also on the Montgomery County Central Committee, District 14. I represent the great people of District 14, and there are members of MCDC members who are in favor of this bill. They're unable to join me today. I believe one is going to be here remotely. But when I leave here today, I will go to Montgomery County and cast a vote for the replacement of State Senator Susan Lee. My decision is based on that, my decision. And because of that, it's undemocratic, because I don't have to consult the people of D16. I don't have to listen to their voice. I don't have to read their letters. It's my decision. And 6 days ago, the people in Pennsylvania did something that the people of Maryland do not have an opportunity to do, and that's participate in a state-run special election. This also happened recently last month in Virginia. Again, they had an opportunity to participate. So states like Delaware and Mississippi, yes, even in Mississippi, they have a right to special election. So I ask you to please consider this bill, not only for the people of Maryland, but for democracy. Thank you.
Thank you. And we have with us former delegate Jimmy Taralou, and you remember this committee, is that right?
Yes, Madam Chair, and members of the Ways and Means Committee. I see a lot of new people and a lot of old friends in new positions. It's actually a great committee. I used to sit where Delegate Long used to be. He probably is carrying on my tradition. Maybe, maybe not. This is actually a great committee with a lot of great content, and sometimes education days get a little long, but normally, you know, not that long. I'm here to testify in support of HB 417. It's a really great bill. I know because I actually introduced it myself back in 2017. You've heard a lot of testimony on this. I'm not going to repeat. I know people, I have a minute and 21 seconds left. I didn't have that when I was a delegate, but keep it short. I'm not going to repeat what people are saying. I just want to say that there have been a lot of concerns raised about the appointment process being able to, in some ways, bring people in who normally wouldn't be brought in, to actually make kind of other kinds of educated decisions about who should be elected as a delegate. I mean, I think when in doubt, we're not always happy with elections. You know, some of us weren't happy about 2016, some of us weren't happy about 2020. I know in the primary of 2018, I wasn't very happy about that election because I lost. But when in doubt, I think we have to bend toward the issue of democracy. When is a chance for people to be elected? When is a chance for us to have direct elections? When is an opportunity in a presidential year to have a big turnout? It's really important that we have democracy. It's really important that we have direct elections. And I think we have to go on that thing. When is there concerns? I think we always have to weigh on the thing of democracy and direct elections. Thank you.
Thank you. There are a couple of questions. I will start with Delegate Wu, then Delegate Griffith.
Thank you, Madam Chair. And Delegate Foley, thank you very much for bringing forward this bill. I would actually think about it the same way. So think about the way the Central Committee can choose and then the voters can choose. By exploring the opportunity to give voters a voice during that 4 years, I think totally makes sense. I just want to appreciate your effort. Thank you.
Thank you,
Isn't
Delegate.
that so? That was a question. So we ask questions. So you
Yes,
gotta-
so the question is, what do you think of the opposition from, right? Because I look at the testimony, there's no opposition there, right? what do you envision the position come from?
Thank you, Delegate. I don't know where the opposition is coming from. You're correct. I don't see opposition here. I know there are some concerns that have been raised, and I think we talked about some of those in terms of, trying to make sure that that people who otherwise wouldn't be able maybe to run a full-scale campaign get an opportunity to serve, and I think that's a real concern. I tried to address that concern in my testimony, both my written testimony and my oral testimony. And that's another reason that I think that maintaining the appointment process in this process, rather than just doing a special election without the appointment process, I think makes sense because it helps us continue on that path. And let me just say that my research has shown that we did a really good job. Everyone in the state of Maryland, the processes that we have done a good job of diversifying our General Assembly. That's another thing that our research has shown, that we actually have done a pretty good job of diversifying the membership in the General Assembly over the years. So thank you for that question.
Delegate Griffith.
Thank you, Madam Chair, and thanks for bringing this bill forward, and thanks for coming out and testifying. I know this is stressful sometimes, as somebody who's testified before. A couple questions. As a former chair of a Central Committee myself, one of the most important roles of the Central Committee members is to represent their constituents, and sometimes that means selecting a member, the representative of the General Assembly. So my first question is tied to the point, just like my constituents don't come down here and vote on bills, right? They've elected me to vote on those bills. How is that different from constituents electing a Central Committee member to represent them in selecting a replacement member of the General Assembly?
Thank you, Delegate. I agree that it's not a totally undemocratic process because Central Committee members are elected by their constituents, and there is an expectation that they would make some appointments. But again, I would point out in this particular bill, the constitutional amendment, if it's adopted, would maintain the appointment process. All it would do is require certain appointees who are selected or appointed during the first 2 years of the term to actually stand for election. Then it's at the midterm, so that the Central Committee then you don't have a handful or a couple of handfuls of people selecting someone to represent a district for 4 years, for the full 4 years. That's what this would do. The Central Committee would still play a very important role in this process and would still be charged with appointing people to the General Assembly, at least for a temporary period of time or perhaps even for the remainder of the term.
Sure, great points. And obviously, the Central Committees, support all of us in our parties in a big, big way. Have they offered support, either party, Central Committees offered support for this bill?
Well, Delegate, I can only speak, I've only heard from the Montgomery County Central Committee. They have not taken a position as a Central Committee on this bill. I think you heard one of my friends here from Montgomery County testifying. She is on the Central Committee. I know there are others on the Central Committee who support this legislation, and those are the people that I've heard from. So that's all I can speak to. And as a Central Committee member myself, I certainly appreciate the role that the Central Committee plays and appreciate the responsibility they have.
Thank you very much, and
Thank
thank you for bringing this bill.
Thank you.
Thank you, Madam Chair.
I'm going to ask, and Delegate, if you could just sit tight, and former Delegate Taralou and ma'am, you guys can both take a step back, but there are two other people here to testify, Emily Scarr and Morgan Drayton. For 2 minutes each, please.
She wants me to go first. Hi, I'm Emily Scarr. I'm the director of Maryland PIRG here in support of HB 417. Maryland PIRG is a statewide, small donor-funded public interest advocacy organization with grassroots members across the state. We work to find common ground around common sense solutions that will help make a healthier, safer, and more secure future. We support the use of special elections for all offices, but think that HB 417 is a smart improvement on our current system and a compromise we can support. 28 states have some sort of special elections process for replacing legislative vacancies. And Maryland is the only state with a 4-year state house term other than North Dakota that relies on the appointment process. So we think it's really time for Maryland to update this process to be more democratic. As Delegate Foley mentioned, there are some benefits to the appointment system, like saving costs, and the least thought that it could help diversify our legislatures to be more representative of the constituency. But I think there are better ways to address those concerns, and I think the compromise legislation really goes at the cost concern especially. One thing that wasn't mentioned about the appointment process is that while Central Committee members are elected, they are by nature a political body set up to further a single political party. So independent voters, opposite party members aren't represented on central committees who are making those voices. And with direct democracy being the #1 aspect of our democracy, being able to cast a vote who represents you, we think leaving those voters out of the process is problematic. And as I mentioned, there are better tools that we can use other than appointments to help make a more representative legislature, which enables folks from all different backgrounds, gender, race, socioeconomic background, age, to run competitive races for office, including small donor public financing, as well as ranked choice voting. So we strongly urge a favorable report.
Thank you.
Hello? Okay, there we go. Good afternoon, Madam Chair, Madam Vice Chair, members of the committee. My name is Morgan Drayton. I'm Policy Manager for Common Cause Maryland, here to offer testimony in support of HB 417. I think we can all agree that ideally the citizens' vote is what will elect a member to the General Assembly, but we do recognize that there are sometimes events that lead to the vacation of a seat between election cycles, and while this bill is not a perfect solution, it is a step towards a more democratic process that gives Marylanders a voice in these situations. We really believe that this is a straightforward bill that will help shift power to fill these legislative vacancies from the executive to the voters of Maryland, and for that reason, we would urge a favorable report. Thank you.
Thank you. Before we move on to the folks signed up virtually, any questions for anyone at the table? Delegate Ebersol.
Thank you, Madam Chair. So just to get a sense of scale, we can have elections for delegates or for senators that can involve tens of thousands of people committing votes, districts that are as large as 130,000 people. I might be asking you a specific question that's hard for you to answer, but what is the fewest number of central committee members in one of the, because it's different from county to county, that could actually nominate somebody to be the delegate and ultimately be the only nominee that the governor has to choose from? Do you have any idea? I'm asking you a rather technical one, but you might know the answer. And it's good for us to get this scale here, I think.
Madam Chair, may I answer that? Thank you, Madam Chair. Thank you, Delegate. Thank you for that question. Yes, while I'm not familiar with the procedures in every central committee, I do know that there are certain central committees where as few as 2 or 3 people vote on an appointment, depending upon the rules of the central committee.
Thank you.
Any other questions for this panel? I have one question, and any one of you can comment on it. So there was some conversation about this bill will help diversify, this bill will help create a more representative legislature. But when I take a look at the most recent appointments that were made, there's Madam Vice Chair, there's Delegate Mira Q. North, there's Delegate Carl Jackson, Delegate Shanika Henson, and our soon-to-be, perhaps coming on this committee, I don't know, Ashanti Martinez. So to me, this would perhaps, although there's arguments for this and against it. This seems to me to be a red flag in terms of when we talk about diversifying. I mean, I just named, I don't know how many individuals that diversify the legislature that were appointed. So if anyone could just comment on
I
that.
think Delegate Foley has done research on this, so she could share more details. The way I think about it is, you're absolutely right, at least in the House, we've seen recently a diversity of appointments that is great. We haven't seen that same level of diversity when it comes for appointments into the Senate, but that could also just be history catching up with itself. The thing I would say is that shouldn't be a goal. The way we diversify our elections shouldn't be through not having people directly elect folks. If that is a goal of this legislature, I would recommend other policy that I see is proven effective to diversify elections. Public financing, which lowers barriers to run for office. Ranked choice voting, both of which have been scientifically shown to help reduce barriers to run for office and build a more representative democracy. I think certainly a central committee process can produce a more diverse legislature, but it isn't by design going to. It depends entirely on who is on a central committee that are appointing people. And so I don't have the data. I think Delegate Foley sounds to have done more research on that.
If I may, Madam Chair. So yes, two things in answer to your question, and I think this is a very valid point that we need to take a look at, and so that's why I did some research on it. And what I actually found was, first of all, as I stated in my testimony, in Montgomery County, this has diversified. There's no question, but the appointment process has diversified our delegation over the years. What I did was I took a look at what I'll call a diversity gain. So, who was a delegate who was not, a person of color or from an underrepresented group that left a seat, and then who replaced them. So, in some cases, we had a diverse person from a diverse group replace a person from a diverse group. And so what I looked at was what happened when the appointment process appointed someone who was from a diverse group, a diversity group, an underrepresented group, replacing someone who wasn't, right? And it's interesting because and as I said, in recent years, I took a look at the 2018 and 2022 elections, and then the appointments from 2018 onward, okay, actually 2018 onward to the present. And what my research showed was that it's actually about the same, and as a matter of fact, if you look at the net diversity gain, the elections in 2018 and 2022 actually produced a net diversity gain of 1 over the appointments in that same period. So I think, Madam Chair, what's happened is, as I stated, we've done a good job in Maryland of diversifying our General Assembly, and so the impact of the appointments process in the past, possibly was greater, but in the current, at least the last 2 election cycles, it seems to be at least a wash. That's what my research showed. But the other thing I would point out is that the appointment process remains in place here. And so if a central committee does what the Montgomery County Central Committee has done, as you pointed out, and has appointed, has made diversity a goal, and has appointed more diverse legislators in the appointment process, they still get appointed. They would just have to run for election. If they were appointed in the first 2 years or less of a term, they would have to run for election then in the midterm, basically. So they would still get appointed. They would still get an upper hand.
Okay, the Vice Chair has some questions.
Thank you, Madam Chair, and thank you so much, Delegate Foley, for the great conversation and discussion around this bill and for the research. I just want to clarify, your research looked at the 2018 cycle and 2022 cycle. Didn't go back any further than that?
Yes, that's correct. That's correct.
Okay, because I think, the research around more people of color and more women that have been running since 2016, we might need to look back a little bit further in order to do a true comparison. So I just wanted to double check the dates of when your research took place. In terms of the date, I think it's 55 days before a candidate's filing. And I just wanted to unpack a little bit more what that looks like in practice, especially when we are talking about potentially diverse candidates that the Central Committee is originally appointing. So 55 days before the certificate of filing, that's giving us November, that someone would have to be appointed by in that time frame, and then they would be on the ballot potentially. So someone who's appointed right around that time, let's say early November, holidays coming in, you get appointed around that time, you are in session, you can't raise any money, and we're talking about candidates who are more diverse candidates, and we know the history of inequality and trying to fundraise, and potentially an opponent who is able to fundraise and sort of competing. And I know that you mentioned that you have been through this yourself, but I do want to just unpack a little bit the time frame, what that looks like when we have a time frame that's right before session, and the opportunity for someone to learn their job, represent their constituency, who's then on the ballot in a few months, and how that sort of interacts with being able to represent their constituency in that time frame, and also being able to be competitive.
Yes, well, thank you, Delegate Wilkinson. We did have a really good conversation about this, and I appreciate your concerns about this in this area. But yeah, I feel that. I live that myself. I'm not a member of, I mean, I am a woman. Maybe that puts me at a disadvantage in my district, but I'm not a member of an underrepresented group. But I did, it was difficult, but I had even less time. I was appointed in December. I was able, and again, I'm not drawing parallels between myself and other candidates. I'm just relating my experience. I was able to raise money, but what tens of thousands of dollars. But what I can say is that what I did experience and what I do think is relevant is the fact that I was an incumbent running coming out of the General Assembly session really did give me a big advantage when I then ran for election on that time frame, which would be the same time frame as the scenario that you outlined. And so it is possible. Is it a cakewalk? No, but it is. I think it is possible to conduct a successful campaign under those circumstances. And the fact that it would be a presidential election means that voter turnout would be higher, and that I think also, as an incumbent, that's also helpful. You know, that's my experience on that. And just going back to your first question, you're absolutely correct. I just looked at the 2018 and 2022 election cycles. I do have information in my written testimony that goes back and looks at all the appointments. So you can go back and look at all the appointments that were made during, going back much further than the 2018 and 2022 election. Part of the problem with the research is that some of it is self-reported, and then they don't. The DLS does not keep statistics on appointments, so you kind of have to figure it out, right, by looking at who the delegates are. So that's why I didn't go back much further, because it's hard to know who the delegates were.
I was also just wondering, Delegate, if your research looked at places that had elected or appointed, and then sometimes were ratified by the voters, legislators who were sort of the first in their area. I would say that, I love my folks in Prince George's or maybe Baltimore City, but I would say that an African American being appointed in Prince George's versus the first African American in Anne Arundel or in Baltimore County is slightly different. So I was wondering how you distinguish between that and sort of how your research values or looks at that a little bit differently?
Thank you, Delegate. Actually, I didn't look at that because it was very hard. I couldn't figure that out. Okay, I couldn't figure that out because, again, the way that demographics are reported on General Assembly members is different for members who are elected than members who are appointed. So it was too difficult to try to figure that out. So I did not look at that.
Delegate Miracle North.
Yes, thank you, Madam Chair, and thank you, Delegate Foley and those that testified on this bill. Yes, so I am the product of an appointment process, but I also have some knowledge of how special elections work. So I want to ask a little more question on the research. Were you able to research jurisdictions that have the combination of what you're trying to propose, an appointment plus a special election? Because I only know of worlds that only have one or the other.
Are you asking me, Delegate, whether I looked at other states that have?
Yeah, other.
Yes.
Mm-hmm.
I am unaware of any other state that has this kind of process.
Okay.
I could be wrong about that. I'm not sure my research was exhaustive, but I am unaware of other states that do this. And I don't know whether.
Delegate Tarlow was going to speak up.
Go ahead.
The U.S. Senate is what he, no, come on up. You can answer the question better than me. I do know there are some, and the National Conference of Legislators probably has it, because that's where we pulled our data, saying we're the only four-year state without this. So I think there might be some that have the hybrid, but I can look at it for you.
Okay, the reason why I ask, I'm curious to see Madam Vice Chair's point, the places, the demographics, socioeconomic factors come into play when you're talking about changing rules in elections. So what areas have these current, if you are able to provide it, what areas have this current combination? Because then the next question would be, if we were to have it, well, what are the demographics of that area that led to that point? To see if we're actually, it's not just diversity, but are we being fair to the demographics of the particular state that we're in when you're proposing something like this?
I don't, as I said, I
My point doesn't come, just the fact the U.S. Senate basically appoints people until the next general election, and then they have a full election. And just one other comment I want to add is that one of the other problems is in my district, in Prince George's County, and it's true that you have people who don't even live in the county making the decision. So there are only 4 people from my district, and there were, I don't know, 65 people. So people in the district get outvoted by everybody else, which is difficult.
Right.
We found out a problem when it was appointment in my district maybe 6 years ago.
Right, and that leads to my last question. I can't remember if I caught this, but can you say more about feedback from potential voters that might have felt slighted by the the appointment process? Were you getting any feedback from just average voters on the process of appointments as well when you were preparing for this legislation?
The answer is yes. I've heard from average voters. I would, Delegate, I wouldn't be truthful if I said I had a deluge of emails or correspondence about it. I'm not sure that the average voter is aware, as aware of this process as we are. Certainly, I have heard from activists who are very concerned about the way this process plays out. And when I was on the Central Committee, and this goes to my point about stress on the Central Committee, when I was on the Central Committee, we got, actually criticized, and they sort of, some voters, again, activists who were paying attention, blamed us for the process and claimed that we were undemocratic, and that why is this select committee deciding who our legislators are? I did hear that when I was on the Central Committee. So, but I would not be honest if I said that it was jamming my inbox. But I have heard from some voters. Yes.
Okay. Thank you.
I have one more follow-up question, and then I'm going to let Dr. Dixon, who has been waiting patiently virtually, to go ahead and testify. So my question is, I've just been sitting here thinking about it. So there's a scenario in which someone is appointed. I'm saying this as a statement, but tell me if I'm saying this wrong. There's a scenario in which someone is appointed and then they have to run in April. So while they're in the legislature, they have to be doing their legislative duties and raising funds and running for office. Is that correct?
Madam Chair, I think actually it would be May.
Okay, May.
Or I'm sorry, June. It would be June.
Let me,
Presidential's different. Yeah, that's right. I'm sorry. Yes. Okay. Council's shaking his head, so I'll defer to council on that. But the answer is that you could not raise funds while you were in the General Assembly.
So how
yes.
are you going to run in an election in which you cannot raise funds immediately, well, while you're still here? I mean, how are you running a campaign?
Can I answer?
Am I missing something?
Well, Madam Chair, I just would point out that I did that. It was a little later than April, okay, but I did that. I didn't raise funds when I was in the General Assembly. I did, but the 55 days is supposed to help with that, right? So 55 days before the filing date, should it be 60 days? I don't know, maybe, but at some point, if you're going to have a special election, it has to have some meaning. So the 55 days is meant to build in a cushion there to help so that money can be raised prior to the session. I think, I do think that the incumbency of being in the General Assembly and then running for election is it's a very powerful tool. It's not the only tool. Fundraising is another tool, but it is a very powerful tool.
Madam Chair, could I add one thing? Sure. I think this really affects only people who are appointed in the first year. I'd say close to an overwhelming majority who get appointed in the first year have actually appointed in the first month of the session. There may be exceptional people, but even now, all the appointments of people going to the administration are being appointed. So all those people have, a year to raise money and to do stuff. The amount of people who get appointed right before the second term is very small. So I think you may be we could do statistics. I think 90% of them are appointed in the first 2 months, and very few of them are appointed the last, month before the second year of the session, which is the only group you're really talking about. People might get appointed in November or October before the second year. Most of them, as you see this year, if you talk about that, soon-to-be Delegate Martinez, Senator Washington, Senator Kelly, and all those people actually have almost a whole year to do that. And so those are the overwhelming number of appointees in the first year, not the ones who get appointed like at the end. So I think those are the ones, are more likely to be the ones we're dealing with. Thank you.
Okay, I appreciate that. I don't know that 100% alleviates my concerns, but I do appreciate that. I thank you all very much. I'm going to let Dr. Dixon go ahead and testify. Dr. Dixon.
Good afternoon, Madam Chair and Vice Chair and committee members. I am Dr. Gail Clark Dixon, and I thank you for the opportunity to testify on behalf of the League of Women Voters of Maryland. The League of Women Voters of Maryland supports House Bill 417, requiring that a special election be held at the same time as the regular statewide primary and general elections in the second year of the term to fill a vacancy in the office of delegate or senator in the General Assembly. If the vacancy occurs on or before the date that is 55 days before the deadline for filing certificates for the regular statewide election. Since 1985, the League of Women Voters of Maryland has supported the use of special elections to fill vacancies in the office of senator or delegate. We strongly believe that legislative representatives should be selected by their constituents rather than potentially serve nearly a full 4-year term based on appointments by the governor. We are pleased that House Bill 417 would establish a uniform requirement for special elections across the state jurisdictions. The League also supports additional actions to improve the transparency of filling legislative vacancies, including statewide standards requiring the Central Committee nominating process, public notice of meetings within the vacated district for constituent input, the public announcement of candidates prior to that meeting, and a publicly recorded vote for each committee member. The League of Women Voters strongly urges a favorable report on House Bill 417. Thank you so much.
Thank you. Are there any questions for Dr. Dixon? Okay, seeing none, thank you for being so patient with us, Dr. Dixon. And thank you, Delegate Foley. That concludes the testimony on House Bill 417.
Thank you, Madam Chair.
Now calling House Bill 422, Delegate Matt Morgan, come on up. And Mike O'Halloran. And then you have two folks testifying virtually.
Yeah, I think,
Is Mike O'Halloran here? I don't
think he's on the sponsor panel.
Oh, okay. He signed up favorable, but I don't think he's here anyway. Okay, go ahead.
Thank you, Madam Chair, Vice Chair, members of the Ways and Means Committee. My pleasure to introduce and present HB 422 to you. This is a bill that, if you're a member of Ways and Means or a member of General Assembly, you know it pretty well. It's titled Motor Fuel Tax Rates Consumer Price Index Adjustment Repeal. So if you're new to the committee or maybe watching out there in the internet somewhere, what this bill does, it stops a presumptive tax increase that occurs every July 1st. So back in 2013, the Maryland General Assembly tied gas tax to CPI. So as inflation goes up, so does our gas tax. I would like to call out to the members of the committee the fiscal note on here. And it says this July 1st, it's an estimated $62 million increase that our consumers will be paying in fuel taxes. Now, the interesting point is I turned this bill in last year. And the fiscal note said $37.5 million. So it's jumped up quite a bit in just 1 year. This is the problem. You know, this tax, I think, it was put forth under good faith years ago when inflation was 1.5%. But now that we're up into double digits, high single digits on inflation, this legislation maxes out at 8%. It's taken tens of millions of dollars out of our local economy and putting it back into government's hands and taking it out of our citizens' hands. And look, if you're going to raise taxes, nobody on this committee, I don't believe, has ever voted for this legislation. You might have voted against it on the floor as an amendment, but no one has voted for this. This is an automatic tax increase that occurs every year. So it makes logical sense that if you're going to raise taxes, you should be able to justify to your constituents what the money is going to be used for. So with that, Madam Chair, I look forward to any questions, because that's always a fun time on this bill. And I would humbly request a favorable report.
Okay, let's go with the two folks that are signed up to testify in favor of the bill, and then we'll go with questions. Dana Schultz, former Delegate Deb Ray, how are you? My former judiciary comrade.
Doing great, Madam Chair. Thank you.
you.
So I support a favorable on this bill. I do believe that when we raise taxes, it should not be automatic, and that the delegates or the senators should be voting on it so that we can hold them accountable. I was really pleased to hear the majority whip come forward today, and he's looking to lower taxes at Seat Pleasant. So, you know, that's great, and he should be commended for that. But in the same time, when taxes go up, the citizens should be able to hold somebody accountable for that. And if you vote against this bill, well, I guess that in turn we could hold you accountable for that because you voted against it. And that in turn means you had the opportunity to reduce our taxes, or in this case, hold them steady. And so if you vote against this, we could hold you accountable and say, well, then you, and really, by not voting on this bill, you voted to increase taxes. The other thing we all know is that transportation is included in the cost of everything. So as we increase our transportation costs by increasing the taxes on it, everything goes up. I know you all are having a hard time finding eggs these days, because or paying for eggs. You know, in some places they're up to $7 or $8 a dozen. This is going to raise the cost of eggs. This is going to raise the cost of every good that we procure. It's going to raise the cost of our vacations. It's going to raise the cost, really, just of living in general. So I encourage a favorable on this. I encourage you to fight for it on the floor to get your fellow delegates and the other chamber to vote in favor of this bill. Thank you.
Thank you. Any questions? Delegate Buckle.
Thank you, Madam Chair, and I guess mainly for the sponsor. So I guess I have just two questions. I appreciate your point. So, you know, the fiscal note says, gee, if we take away the automatic CPI raise, we'll lose $62 million in revenue. But we'd have the ability to get that revenue back if we thought we really needed it, right? I mean, we could come in every year and say, we need the revenue, we have to adjust the tax rate.
That's true. I mean, we meet every year, as far as I know. And
you haven't been left out of any of the meetings, believe me.
Yeah, and right. And if the General Assembly needed to justify the revenue for a particular project, they could easily raise the tax rate the following year and say this is the reason why. And look, I've heard the argument before about lost revenues to the state with this bill. And the fact is that motorists overwhelmingly pay into the Transportation Trust Fund. That's what makes up the bulk of that fund. Right. 61% of that fund is spent on mass transit. So the people who are paying into the fund are really not receiving the majority of the revenue back. And then last time I checked, you know, if you ride Metro, that's not connected to CPI.
Well, that's kind of my second, and Madam Chair, my only really follow-up question. I was thinking more about EVs. I don't own an EV. Maybe one day I will. I don't have anything philosophically against them. I'm just looking for the marketplace. But so I don't know how this works. Maybe you don't either. But if I drive a car that has gas, I had to put about $70 worth of gas to drive from my home in Western Maryland here every week. And I pay a certain percentage of that is this gas tax that goes into the Transportation Trust Fund predominantly. If I had an electric vehicle and I showed up, we have, you guys have a lot of Royal Farms and Wawas. We have places called Sheetz. Delegate Jones knows about Sheetz. She's from Allegheny County originally. And if I go to Sheetz, they have these electric vehicle charging stations. Great. You plug your car in there, I assume, and it charges you. And you have to get charged something. To your knowledge, is there a consumer price index automatic escalator on how people who use electric vehicles get charged? Because the price of power is going up every year too. Are they getting this, or is it just those of us who put gas in our car?
That's a great point, Delegate. And to my knowledge, the EVs do not contribute to the Transportation Trust Fund through a motor vehicle's mileage tax or a rate on their charging. Now, they do contribute to that fund because of their tags. When they pay and register their vehicle, money goes into that fund from them. But look, if this bill doesn't get passed, the cumulative effect is Maryland's tax rate will be the second highest in the nation
for gas
on a year. And EVs, while they use the same roads that gas-powered vehicles drive on, not only do they not contribute to that infrastructure in a meaningful way like a motorist car does, we also give them a tax credit in many cases.
Yeah,
so
that's what I looked that up to see what the rate
an
was, and then we
equity
talked about
issue,
incentives.
absolutely, I think there should be some adjustments probably made.
Thank you.
For the record, I don't think Delegate Buckle would know how to operate an EV. So there's some problems with that.
If it was on his cell phone, ma'am,
he can barely work. Delegate Miller.
Thank you, Madam Chair. So this was a topic at we had our Farm Bureau legislative update today, and this is a big cost, as we all know, the cost of food, of course, the egg situation, but all of that is rising, and they're very concerned about this tax and the cost rising and the impact of that on the cost of food over the coming years. So do you have any information about that, or have you seen any information?
No, I mean, I don't have any information at hand about this, but it does make sense. I mean, look, every product to get to market has to use some type of fuel to get there. Now, I don't want to mislead anybody. Most of that's done with diesel fuel. This is for gasoline. But with that being said, I mean, transportation costs, it doesn't make a difference if you're using that money to get to your product to market, or you're getting your workers, your employees to their place of work. When the cost goes up, that has to be accounted and is a contributing factor. And right now, like I said, this would bring our gas tax just in our state, just the state taxes alone, up to close to 50 cents a gallon, which would be the second highest in the nation, only surpassed by California.
Okay, any other questions? Okay, seeing none, thank you, Delegate. Thank you, Deb, Ray. That concludes the testimony on House Bill 422. Calling Delegate Valderrama. Come on up, House Bill 443. And would you like anyone to come up with you?
Thank you, Madam Chair. I think I have a gentleman here from the department. Is Mr. Glazer here?
You have Mr. Oh, yeah.
Okay, thank you.
There, and Carol Colbeth?
No, she's my staffer.
Oh, okay. Sorry.
No problem. Thank you, Madam Chair, Madam Vice Chair, members of the Ways and Means Committee. Good afternoon. For the record, Chris Valderrama here to present House Bill 443. And also for the record, I do know how to run an EV, but in canoes to Delegate Buckle. So, yeah. Having said that, thank you again for having me this afternoon. I'm here to present a property tax exemption for dwellings of surviving spouses of disabled veterans. I know I have several veterans serving on this committee. Thank you for your service. And even if you didn't serve in the military, I'm sure you have a family, friend, colleague who has served in the military. And so the purpose of this legislation, House Bill 443, is twofold. One, it clarifies that all surviving spouses who receive dependency and indemnity compensation from the U.S. Veterans Administration are eligible for a property tax exemption under Section 7-208 of the Property Tax Article of the Maryland Code. I am by no means an attorney or a tax attorney, but just do the research. With that said, the legislation, secondly, it streamlines the application process for this exemption by accepting evidence that a surviving spouse receives dependency and indemnity compensation from the administration. By way of explanation, dependency and indemnity compensation is a monthly benefit that is paid to the surviving spouses of disabled veterans based on their military rank, number of children under age of 18 who lives with their surviving spouse. The base monthly rate of compensation ranges from $1,154 for an entry-level soldier to $2,463 for the most senior ranking officers. And for each child under 18, a surviving spouse would receive an additional benefit of $250. The dependency and indemnity compensation is granted by the VA to surviving spouses of service members who, 1, die in the line of duty or while on active duty, 2, die of a service-related illness, 3, die of a non-service-related illness if the veteran was rated 100% disabled for a period of a decade. The application process for dependency and indemnity compensation is one that is rigorous and requires that discharge papers, the full military record, and all medical evidence are reviewed to prove entitlement to the benefit. But the problem is here, and this what my bill seeks to rectify. So although Section 7-208 of the Property Tax Article clearly states that, quote, surviving spouse means an individual who has not remarried and who, 1, is the surviving spouse of a disabled veteran, 2, is the surviving spouse of an individual who died in the line of duty, or 3, which is what we trying to establish here, receives dependency and indemnity compensation from the United States Department of Veterans Affairs. So in practice, only surviving spouses of disabled veterans and those that die in the line of duty are granted a property tax exemption. The application of this statute totally ignores surviving spouses who receive D&I, the dependency and indemnity compensation, because their service member died of a service-related injury. I want to emphasize to the members here today that the language of the statute is unequivocal. It reads, quote, surviving spouse means. It does not use more illustrative language like could include or may include. So the statute states what it means. And I'll quote, a surviving spouse means an individual who has not remarried and who receives dependency and indemnity compensation from the United States Department of Veterans Affairs. So to illustrate how this omission impacts real Maryland citizens, I have a constituent who brought this issue to me several years ago now, so this is not the first time I've brought forth this legislation. I have a constituent whose spouse, several years back, many years back now, died of a service-related injury. And he, the husband who passed, in the 1950s, he was a service member on board a naval vessel that witnessed nuclear testing in the South Pacific. So because of this exposure to a nuclear blast at close proximity, the spouse died of a rare form of cancer that the VA determined was presumptively caused by a service-related injury. Though after a rigorous review of the service member's military records and all of his medical records, the spouse was eventually granted dependency and indemnity compensation. However, the veteran never had a chance to apply for a total and permanent disability because his cancer was so aggressive that he died shortly after his diagnosis. And I think we can all agree here that the last thing his family members were thinking about as their loved one was dying was adequate documentation of a 100% disability so they would qualify for a property tax exemption by the state of Maryland. I know it wouldn't be on my mind if that was my family member. And why would it have been on their mind? The statute is clear that those who receive dependency and indemnity benefits from the US VA for any reason qualify as disabled veterans and should be granted this property tax exemption by the state of Maryland. Unfortunately, my constituent was denied the tax exemption because she could not provide documentation of a total and permanent disability rating from the Veterans Administration, which is an acceptable reason as the Maryland Code is currently applied. Moreover, the Property Article 7-208 states that a veteran can apply for a total disability posthumously. The Maryland VA denies that such a rating is available regardless of what this statute states. So my constituent unsuccessfully appealed the denial and so does not receive this tax exemption. I believe that this spouse was unfairly denied a benefit from the state of Maryland despite the fact that their military service caused her husband's death. So finally, this legislation seeks to streamline the process for the tax exemption by accepting proof that the VA issued dependency and indemnity compensation. And because the Department of Veterans Affairs reviews all of the service members' military service records and all of the service members' medical records, it makes sense to accept the VA's determination of disability and service-related illness, rather than put families through a complicated and duplicative process by the state of Maryland. So for all the reasons I've mentioned, I would ask for a favorable report of this legislation. Thank you.
Thank you. Are there any questions for Delegate Valderrama? Or, are you gonna go ahead? I'm sorry.
Good afternoon, Chair and Vice Chair. My name is Jonathan Glazer, and I'm the Legislative Director for the Department of Assessments and Taxation. We're doing support with 2 amendments for this bill. So House Bill 443 expands a current tax credit to also include surviving spouses who received the DIC from the United States Department of Veterans Affairs and meet certain requirements. Therefore, the department recommends that an amendment be adopted to reflect that adding a surviving spouse who receives DIC would be a new benefit of the credit, as the documentation required for the DIC would expand who is eligible for the current credit. This will help meet the legislative intent of the sponsor. In addition to the First Amendment, due to the fiscal impact as indicated by the Department of Veterans Affairs through their data, the department also recommends that an additional amendment be adopted to change the credit to an authorizing tax credit for the counties instead of a mandate that is administered by the department to allow counties to opt in or out to this additional optional credit, so it is not a local mandate. The Department of Veterans Affairs has indicated to SSTAT, since they're the ones that come up with these ratings for SSTAT, that this would include new people that the department has previously denied this tax credit to.
Thank you. Are there any questions? Okay, seeing none. Thank you, Delegate Valderrama. That concludes the testimony on House Bill 443.
Thank you, Madam Chair.
Thank you. Calling House Bill 410, Delegate Rosenberg.
Thank you, Madam Chair and members of the committee, and thank you for including on the committee report the previous election bill that I came before you, and I hope we'll be able to do the same thing here, if I can make the case. This bill deals with proposes three changes to the law. The first two are not hypothetical. There have been instances in Maryland that would have been addressed by this bill had this bill been law, and the other deals with what at the moment is a hypothetical, but is not likely to be a hypothetical for much longer, and I'll get to that at the end. First is changing a polling place location. What the bill would say is that if a polling place change is proposed by the local board or the state board more than 21 days before the election, that there has to be notice to people who've signed up to receive such a notice, as well as to all candidates on the ballot, so that there is a public hearing where the voters affected by the proposed change can make their case. This specifically happened in our legislative district, in the 41st district this past year, when, because of the closing of a school, the polling place was changed from the school to a fire station. Well, the fire station was at the intersection of a busy intersection, no parking on site. The only parking was across the street at a convenient, in front of a 7-Eleven, at a shopping center, and you had to cross a busy intersection to get there. After the primary, we were able to resolve this, and the City Board of Elections was very responsive, but not until the primary election had been held at the very inconvenient location of the fire station. We moved the polling place to a public high school for the general. So what this bill says is, if it's not an emergency, if the proposed change is made public more than 21 days before the election, there must be a public meeting so that the affected voters get an opportunity to express their concerns, and there must be notice of that meeting provided to any group that is signed up in advance and to the relevant elected officials and candidates for office who would be on the ballot in the precinct that's affected. The other change that is not a hypothetical has to do with Public Information Act requests. And that is that I originally read in the Washington Post that there were several, shall we say, red states where, or states other than Maryland, where Information Act requests had been made close to the election and were disruptive to the process of preparing for the election. And when I made this, and in drafting this bill, I dealt with our state board and became aware of the fact that such requests, burdensome requests, had been made to the state board, to local boards here, and that it was that buttressed my view that we needed to take action to provide for a court action where the burden is on the state board of elections or the local board of elections to demonstrate that compliance with the request for information would have a deleterious effect on the public interest and on the preparations for the election, so that this would apply, this option would be available to the local board if the request for public information occurred within 90 days or less of primary or general or the certification of the primary or general. And you would have to go, the election board would have the burden of going to court, and I'm demonstrating to the trial court judge that the legal standard in this bill, hopefully the law, had been met to deny what would otherwise be a valid Public Information Act request. So this is, as I said, not hypothetical, but potentially very disruptive to the election process to be burdened by these Public Information Act requests. Third issue that this bill would address is a provision in existing law which says that you cannot willfully or knowingly, the standard, criminal law standard, act with fraud or deceit and other options to deceive someone regarding their decision with the intent to affect their decision whether to go to the polls to vote. So when this language was added to the law more than a dozen years ago, that's how we voted. We went to the polls. But since this is a criminal law, since criminal laws are to be narrowly construed and narrowly interpreted by a judge, it's very unlikely that if someone used the same deceptive tactics, same intent, to affect someone's decision whether to vote by mail, that this current law would affect that, because it says go to the polls. So what the bill would do is just broaden that existing prohibition to include such actions designed to affect someone's decision whether to go to the polls or whether to vote by any other lawful means. So this committee has been very responsive over the years to our efforts to make sure that we have a clean process, that we are encouraging, enabling people to cast their vote. And I think the three provisions of this bill are consistent with what historically this committee has done and made part of the state law, and would urge a favorable report. Thank you.
Thank you. Are there any questions for Delegate Rosenberg? Okay, seeing none, we do have one individual, Deb Ray, signed up to testify unfavorably virtually, if she's in the waiting room. Okay, I think she's coming.
Hello? Hello? Hello?
We can't see you. 1 second.
Hello? This is Linda Dorsey Walker. Can you hear me?
Can you wait 1 second, please? Okay, use your error. My pages are all mixed up. So, is Kevin Canale here? Come on up. That was on your bill, Ms. Jones, Delegate Jones, yeah. So you can look forward to that.
Thank you, Madam Chair and members of the committee. Kevin Canale here on behalf of the Maryland Association of Counties in support of House Bill 410. You have my written testimony. I won't take too much of your time. We do appreciate Delegate Rosenberg giving a lot of flexibility to our local boards for the 21-day requirement and moving a polling place. That gives them plenty of time to comply with the bill, so we appreciate that. And we certainly appreciate the part about the reasonable temporary denial of a PIA request that is obviously meant to impair our local boards or state board ability to prepare for an election. This is going to happen more frequently, unfortunately, we predict. So we think it's a reasonable bill. We think it sets a reasonable process to make sure that everybody has a chance to weigh in on that temporary denial. And with that, we'd ask for a favorable report, and I'm happy to answer any questions.
Thank you. Are there any questions for Mr. Canale? Okay, seeing none, thank you. Is Catherine Berry here?
Good afternoon, Madam Chair, members of the committee. I'm not going to take up a lot of your time. You do have my written testimony. I'm here supporting this bill on behalf of the Maryland Association of Election Officials. I'm also the election director in Carroll County. A couple of just comments and a suggestion for an amendment of this bill. We do already provide public notice when we have to make polling place changes. Current election law requires all polling place changes really to be established 13 weeks before the election. Anything after that becomes an emergency change that goes to the State Board of Elections. But we do offer the opportunity for testimony and public meeting for voters to come and speak with us about any concerns that they have. Some of the polling place locations are restricted by guidelines of, not crossing precinct boundaries and that type of thing as well. We are in support of the PIA request. We did have an exuberant amount of PIA requests for this past election. Some of those have to do with software versions, Wi-Fi capabilities, asking for personal information about our election judges, questions about the 2020 election, polling place and ballot drop box surveillance footage and that kind of thing. So we appreciate the delegates' efforts to put this bill in. I hope you will give a provide support on the bill. Thank you. Anyone has any questions?
Any questions for Ms. Berry? Okay, seeing none, thank you. Now we will have Ms. Linda Dorsey Walker virtually.
Hello, can you hear me?
We can hear you. Can you,
Good.
Can you show your face? One moment. Are you capable of showing your face?
Actually, I'm trying to do that both virtually on the computer and on my cell phone, but it doesn't seem to be occurring.
Can you hold on 1 second, please?
Hello.
There you are, yes. Okay, ma'am, go right ahead.
Hi, I'm Linda Dorsey Walker. I am elected to the Baltimore County Democratic State Central Committee and have been elected to the Central Committee since 1994 on the Democratic side. I think that now makes me the longest serving Central Committee member in the Democratic Party with the retirement of Senator Kelly. I want to come in support of House Bill 410 because it avoids what I feel are arbitrary and capricious attempts to thwart or slow down the electoral process due to frivolous requests, PIA requests, to examine and re-examine certain election records and materials, as we saw demonstrated in both Arizona and Georgia in 2020 and 2021. Our democracy is under attack in many parts of the country that have failed to anticipate this kind of attack may come And this is our chance to anticipate how we will respond should those kinds of attacks become more common in the state of Maryland. In addition, this bill would help prevent some of, I don't know if it will totally prevent, but will help deter some of the deceptive practices around robocalling, such as calling people who have received mail-in materials and telling them that if it wasn't received on a certain color paper, then they must go instead to a polling place and can't mail in the document. There are many, many of those kinds of deceptive practices that are taking place, especially in and around minority communities. In addition to that, I would add that in addition to requiring not just that change of polling places be reported, that is, the last speaker said it's done many weeks in advance when you want to change a polling place. The problem is it's not always shared with the local government officials who should be advised of it. In addition to their decision to use or not use their option, as was given in the last two elections, for an additional early voting site.
Thank you, Ms.
In some
Walker.
counties,
Thank you, Ms.
that was
Walker.
not done.
Thank you. Are there any questions for Ms. Dorsey Walker? Okay, seeing none, thank you. And we have an unfavorable signed up, Katja Harper. She's virtual. Oh, she is not here. Okay, thank you. Well, that concludes the testimony on House Bill 410. Thank you, Delegate Rosenberg. Calling Delegate Jones, House Bill 441. And committee, I should have mentioned, but I'm sure you saw him unless he's disguised by his new haircut, that Jared Demarinis is here with us from the State Board of Elections, that he can answer questions for you on any of these electoral related bills. Whenever you're ready, Delegate.
Thank you so much. Chair Atterbury, Vice Chair Wilkins, and members of the Ways and Means Committee, happy Valentine's Day. For the record, I am Delegate Dana Jones. Exploratory and draft committees are currently exempt from the same regulations that keep our campaign finance committees transparent and the ability to audit them. This exemption to the rules is dangerous and prevents the general public and interested parties from being able to properly review and monitor these committees. Exploratory and draft committees help determine whether or not elected officials have the viability to run for office. But if the individual decides not to run for the office of which they are exploring, the financial details of the committee do not need to be disclosed. An exploratory committee is defined as an entity established by a prospective candidate for public office to determine the potential candidate's viability for that public office. And a draft committee is an entity that is organized to encourage a potential candidate to run for office, but is not authorized by the potential candidate. Current Maryland law fails to provide oversight and transparency for exploratory and draft committees. HB 441 would simply ensure transparency by requiring that these election committees comply with campaign finance disclosure laws, limit the purpose for which funds can be expended, and establish specific processes for dissolving these committees. A substantive amendment that I have included for provisions for reporting procedures, removing contribution limits, expanding the list of permitted expenditures, clarifying that candidate committees can purchase supplies at fair market value, adding a list for the use of leftover funds, and a 120-day deadline for the reporting of such records after candidacy is in fact filed. In your floor system, you'll see a letter of support for the Attorney General, and I respectfully urge a favorable report as amended on HB 441. Thank you.
Thank you. Mr. Damaris, are you testifying? Are you here for questions? Here for questions. Okay. Are there any questions for the delegate or Mr. Damaris? Okay, seeing none. You just looked so on point with your haircut, everybody got scared.
I know.
So that concludes the testimony on House Bill 441. Delegate Jones, House Bill 5 And if there are two other folks
February.
signed up favorable, if you want them to come up, they can come up.
Thank you. Thanks, friend. Thank you very much.
Kevin Canali and Mark Cicero.
All right, HB 508. Chair Atterbury, Vice Chair Wilkins, and members of the Ways and Means Committee, a continued happy Valentine's Day to you. For the record, I am Delegate Dana Jones. I come before you today to testify on legislation that was passed unanimously last year by this committee and on the House floor. HB 508 would require a county or municipality to define who is disabled law enforcement officer or rescue worker, and expanding an already existing tax credit to disabled federal officers. Many counties in Maryland offer disabled state law enforcement and rescue workers property tax credit. A majority of these individuals lives on fixed incomes due to their injuries, and this tax credit provides financial relief to them and their families. Currently, this benefit is only available to state agents. 508 would expand the benefit to disabled federal agents and the ability for municipalities and counties to define this. It also expands the ability for them living in Maryland during their declaration as disabled or any time within 5 years prior, which is critical, and one of my panelists can speak to the importance of that when receiving care outside the state. This bill does not specify what specific agents or officers must receive the credit by counties or municipalities, but examples of agents, and we spoke of this last year, were federal police officers, Job Series 008 and 1811. And this includes federal officers from the U.S. Capitol Police, the National Institute of Health, Department of Defense, Department of Veteran Affairs, FBI, ATF, on and on. So how did we get here, and how was this brought to me by a constituent and a dear friend? 2 years ago, we watched in horror as insurrectionists stormed the U.S. Capitol. The only thing that stopped these violent actors from reaching our elected officials and their staff was the heroic actions taken by our Capitol Police officers and Metropolitan Police. Over 80 Capitol Police officers were injured during the riot, and over 150 officers in total from several local agencies became injured as a result of the attack. Unfortunately, under the current law, counties would not be allowed to extend this benefit to those brave men and women who fought to preserve our democracy on that dark day. I believe requiring counties and municipalities to define by law their definition of law enforcement officer or rescue worker will enable current property tax credits to be extended to those disabled federal agents. This shows how we value these federal officers from Maryland, their families, and their dedication to our country. It shows our intent on retaining these brave men and women in Maryland as neighbors, community members, and the heroes that they are. I am, in your floor system, you will see the letters of support from the Maryland General Assembly's Veteran Caucus, as a significant number of veterans become federal officers after their service in the military, the United States Capitol Police, federal law enforcement officers, and of course, you'll hear from MACO. I respectfully urge a favorable report on this enabling legislation, and I thank you so much.
So, Chair Atterbury, Vice Chair Wilkins, and members of the Ways and Means Committee. For the record, my name is Mark Cicero, and I am a disabled federal agent living in Maryland. I was injured in February of 2010 and required 3 back surgeries over a period of 2 years to try and eliminate the pain. While these surgeries were mildly successful, I still had pain and was labeled disabled and unable to work. While hearing of other states having laws on the books that allow disabled law enforcement to be exempt from county property taxes, I was surprised that while Maryland does allow local and county law enforcement to be exempt from county property taxes via Public Law 3-101E, does not allow this for federal agents. It makes no sense that federal agents are not included in this provision of the law that allows the exemption of county property taxes if disabled while performing the functions of their job, while other law enforcement agencies are. While military retirees with disability, even 100% disability, are able to start a new career and their salary just supplements their disability retirement, Federal agents are the complete opposite. Once a federal agent is labeled disabled, we are given a portion of our salary from when we are working. If we are able to get clearance from a doctor to start working in any field, we would then get that amount deducted from our salary for the rest of our lives, regardless if we continued working or not. Due to the geographic location, Maryland is home to many federal agents who have been injured in the line of duty, like myself. This tax benefit would provide financial relief for those that have been injured while serving our country. For these reasons, and the fact that these men and women have put their lives at risk, just like local law enforcement, I believe that we should receive the same benefits and tax breaks that they are entitled to in Maryland. Thank you.
Mr. Catali?
Good afternoon, Madam Chair and members of the committee. Kevin Canali here on behalf of the Maryland Association of Counties in support of House Bill 508. This bill grants counties more flexibility with a current local option property tax credit. We appreciate that the bill gives us broad discretion in determining who should qualify and be eligible for this credit. As the delegate mentioned, we're currently restricted by who can qualify, so we feel like this gives us a lot more broad flexibility to tailor these credits to meet our citizens' needs. And of course, we're able to hold public hearings, hear from our residents exactly what they'd like to see, and then tailor this credit to meet the needs of our constituents. So we appreciate the flexibility, and we'd ask for a favorable report on House Bill 508.
Thank you. Are there any questions for Delegate Jones or her panel? Okay, seeing none, thank you. That concludes the questions. Yeah, it does. That concludes the testimony on House Bill 508. House Bill 404, Delegate Feldmark. And you have Mr. Glazer. Is he coming up with you? Okay.
Thank you, Madam Chair, and Madam Vice Chair, who may be back soon. And thank you, committee members. Good afternoon. For the record, I'm Delegate Jessica Feldmark, here to ask for your favorable report on House Bill 404. Now, for those of you who were part of this committee last year, you will recall that we had a local bill from Baltimore County to allow county government to provide a tax credit for a hardship exemption for homeowners who otherwise would have qualified for the homeowner property tax credit, but because of a hardship that they experienced, their income disqualified them from receiving the homeowner's property tax credit. So, why does higher income sound like a hardship? Well, usually it doesn't, but what we're talking about is instances where because of an illness, injury, damage to the home, right, some major expense caused the homeowner to have to get additional income to cover that expense. So it may have been a withdrawal from retirement savings. It may have been scrounging and getting gifts from family members and friends to help cover this exorbitant expense. Under the homeowner's property tax credit, all of those sources of funds count as income, which then can potentially disqualify them from receiving the tax credit. So we were able to accomplish this for Baltimore County. It sounded like a great idea. We got it passed through the General Assembly. It is enacted, and this bill, House Bill 404, would take that statewide and allow other counties the same ability to establish a tax credit to help homeowners who, but for some hardship that they experienced, would have qualified for the homeowner's property tax credit. So with that, I will again ask for your favorable report and welcome any questions.
And good afternoon again, Chair Atterbury. My name is Jonathan Glazer, and I'm the Legislative Director for the Department of Assessments and Taxation. House Bill 404 is enabling legislation that permits any county and municipality or the city of Baltimore to grant a property tax credit for certain homeowners who have suffered a hardship. The department is in full support of this legislation as it provides local jurisdictions additional tools to help homeowners while also allowing local jurisdictions to tailor the credit and eligibility for the credit to meet local needs. For these reasons, SDAT is strongly urges a favorable vote on House Bill 404.
Thank you, and we have a question from Delegate Barnes.
Thank you, Madam Chair. Delegate Feldmark, thank you for the bill. You stated that you all are doing this in Baltimore County currently, correct?
It was enacted last year to authorize Baltimore County.
All right, and do we know how many people have taken advantage of this that you're seeking to now do this statewide?
So, sure, I'll let Mr. Glazer speak to that. My understanding is that it has not yet been implemented in Baltimore County, even though it's authorized.
Last year's legislation enabled Baltimore County to do this if they wanted to. They have not acted upon that yet. This legislation is simply expanding the enabling to enable any jurisdiction to do this, but no one has done it yet.
So with Baltimore County having the authorization to do it, do we know why they have not done it, or why no one has taken advantage of it? And the reason why I'm asking, because you are now coming to ask for us to do this throughout the state, and we've had it in Baltimore County where no one has already taken advantage of it.
I would say counties are the ones that administer local tax credits, so it'd be totally up to the county.
So I do think, and I believe you have testimony from Baltimore County sort of speaking to this. They are finding the program difficult to administer as they look at implementing it. So they are actually asked for an amendment to allow SDAT to administer or to allow the county to contract with SDAT to administer the program. My understanding from conversations with SDAT is that that is not their preferred solution. I think there is a matter of sort of the administration involved in the program, and I actually think that expanding it to other counties may provide an opportunity for counties to work together for some efficiencies in finding some third-party help, whether it's SDAT or someone else, to help with that administration.
Thank you, Madam Chair.
Are there any other questions? Okay, seeing none, thank you. Kevin Canali?
All right. Good afternoon, Madam Chair and members of the committee. Kevin Canali here on behalf of the Maryland Association of Counties in support of the bill with an amendment. The amendment addresses the question that was just asked. So Baltimore County is very interested in actually carrying out the enabling legislation. They have found that it is incredibly burdensome to administer this local option credit. So we, like was mentioned earlier with Baltimore County, we asked for an amendment to allow counties to contract with SDAT to administer this credit. The issue here seems to be all of the documentation that is required to prove the hardship. We don't have a lot of the software that maybe SDAT has access to, and so we want this. We appreciate the enabling authority. Many counties are interested in doing this, but again, we would appreciate the ability to contract with SDAT to administer the credit.
Thank you. Delegate Barnes.
Thank you, Madam Chair. So I'm hearing your testimony, and you're explaining the complications that Baltimore County is having. And dare do I say that other counties will probably fall in the same posture. So I'm just trying to understand, and maybe this is a question for SDAT. Do you guys have the resources and the capability to now be the administering agent, if you will, for other counties throughout the state of Maryland?
So the Department of Assessments and Taxation has traditionally only administered statewide tax credits. Homeowners, homestead, renters, we would really resist that amendment, but we really like her bill as originally put in. And we would encourage that bill to be passed as originally put in. It sounds like Baltimore County would like some of our data and some of our help. We're happy to give them data and help, but we cannot administer the credit for them, and we don't want to start administering county tax credits. There's a ton of county optional tax credits, but unfortunately the department wouldn't want to start doing all of those.
Thank you, Madam Chair.
If I may,
That's all I have.
Of course, sure.
Thank you.
Are there any other questions? Okay, seeing none, thank you. That concludes the testimony on House Bill 404. Calling Delegate Feldmark, House Bill 535. And I have Morgan Drayton and Emily Scarr signed up. If you would like them to come up.
Sure, sure. Thank you, Madam Chair, Madam Vice Chair, and members of the committee. For the record, I'm Delegate Jessica Feldmark, here to ask for your favorable report on House Bill 535. So House Bill 535, the main purpose of this legislation is to let our local boards of elections begin canvassing mail-in ballots before Election Day to help prevent and at least minimize any delays in election results. This may sound familiar to you. We passed this bill last year. So essentially, this bill would codify the way we have run, or the way our local boards of elections have run elections in 2020 under a state of emergency, and then again in 2022, thanks to the court's intervention after Governor Hogan vetoed the legislation that this body passed last year. I do want to highlight just a couple of changes from last year's bill. One, this bill sets a 2-business-day time limit for the local board of elections to record receipt of a mail-in ballot. So as you know, if you voted by mail-in ballot, you would get notified that your ballot had been received. That did not always happen as promptly as we would have liked, and left a number of people wondering about the status of the ballot they had returned. So this would set a limit that it had to be entered within 2 business days. You have received favorable with amendment testimony from Mayo. I believe you'll be hearing from them shortly. They're requesting 5 business days. I think that is probably excessive for the pre-printed mail-in ballots that have barcodes, but as they explained in their testimony, for for the email delivered ballots, right? Those are more complicated to process. And so I do think the 5-day time frame may be more reasonable if we limit it to those internet delivery ballots. The other change to note from last year is that last year's bill was strictly permissive in allowing the local boards to start their canvassing early. This bill would require it, but has a provision that the administrator of the State Board of Elections can provide a waiver if the local board doesn't need to start canvassing early because of the small number of ballots, mail-in ballots received. So again, this is pretty familiar to folks who have been on this committee, but we're gonna try to get it done and codified this time so we can move forward consistently, and I ask for your favorable report. Thank you.
Ms. Scarr?
Hello again. For the record, my name is Emily Scarr. I'm the director of Maryland PIRG here in support of HB 535. For those of you who were in office last year, thank you for supporting this measure. We were disappointed that Governor Hogan vetoed the similar bill, and we hope that you will move quickly to pass it. This is a needed response to the increase in mail-in voting that we've seen in recent elections. And as the delegate explained, most of what's covered by this bill is already operationally being done by the boards of elections. This is just codifying that into law, especially the early processing of ballots before Election Day and enabling voters who mistakenly did not sign their mail-in ballot envelope the opportunity to fix that error. My testimony has some data on the last a couple of elections on both how many voters' ballots were rejected because of this paperwork error, as well as the most recent election, the number of voters they were able to reach and fix that error so their votes could be cast. We think nobody should lose their voice or their vote because they failed to sign a piece of paper and not their actual ballot. And obviously, as we see more folks voting by mail, we want to make sure our election results are returned in a timely manner. So we respectfully urge a favorable report. Thank you.
Good afternoon again. For the record, my name is Morgan Drayton, Policy Manager for Common Cause Maryland, here to offer testimony in support of HB 535. I will keep my testimony short. Common Cause Maryland strongly supported this bill last year when it made it all the way to the governor's desk, and we hope to do so again this session. We believe that this bill provides really common sense steps to improve our mail-in voting process, as well as provides necessary support to our state and local election boards. It also addresses issues that have long been a challenge for voters, especially voters from vulnerable communities, like those with disabilities, students, and the elderly who have relied on this method of voting for years. And for those reasons, we would request a favorable report. Thank you.
Thank you. Questions? Delegate Griffin.
Thank you, Madam Chair, and thanks for bringing this bill back. A couple quick questions. So how many states currently allow the early canvass?
I do not know that off the top of my head. I don't know if you have an idea.
I don't have that off the top of my head, but we can find out.
Sure.
I know it is. I think we're like, wait, correct me if I'm wrong. I'll have to double check this. But I think we're one of the only states that had it seem like we had to allow it. I think it is very common. I'll find out the numbers, but we actually had something in statute forbidding it, which is what was so unusual.
Sure. Well, I know there's at least 2 states that have legalized it, Oregon and Florida. Those 2 states, do you know the security measures they put in place to go along with the early canvass?
I don't. Does it go beyond the sworn oaths at all?
Sure. So both those states, one very blue state and one purplish red state, both require signature verification to go along with this. And the reason why they felt signature verification was equitable was because when you register to vote, you sign a form and your signature on there and use that signature. And every single registered voter in the state, there's a signature on file. And the reason why this is a potential concern is because some of the debate last year with if someone shows up, sends in a ballot, forgets to, didn't mean to, whatever the case may be, they show up on election day, and potentially that ballot gets double cast, right? And there's potential for that, some of those errors. So with the signature verification those 2 states have put in place, if someone shows up to vote on election day, they can look and say, well, your ballot's been sent in, your signature was verified, ballots counted, and we're not going to accept your in-person ballot because it's already been verified. And almost every single time this happens, it's a simple error. It's not deliberate. It's just these errors happen, but somebody shows up and is dejected because they say they haven't voted when they actually have. Are you guys agreeable to some, and apparently we have the technology in place with our current systems, we just have to spend a little bit of money to get the equipment to handle this. And we wouldn't need to gather any additional information because we already have it. Would you be agreeable to adding the same security measures that Oregon has implemented to go along with this, to make sure we're verifying folks' signatures just for mail-in ballots?
So in the scenario you're describing, the way that would work in Maryland, if someone had requested a mail-in ballot, they would be given a provisional ballot at the polling place.
Yes, but the provisional ballot would not count because their mail-in ballots already been canvassed.
Right, so the provisional ballot would be rejected.
Right, so the individual claiming at the polling place that I have not voted their only recourse will be to refer to the Attorney General. And
No,
the ballot, because the ballot's already been counted, and they cannot dispute the counted ballot.
but the provisional ballot wouldn't be rejected until after, they would be able to vote the provisional ballot
But it
on
wouldn't
the
be
day of
canvassed.
election.
But it wouldn't be canvassed because their ballot's already been canvassed by mail.
If they had a ballot that they mailed in that was canvassed, then the provisional ballot would be rejected.
Correct.
But on election day or at an early voting center, there may be a mail-in ballot that is in transit, right, has not been counted. So they would still have the opportunity to vote the provisional ballot, and it wouldn't be rejected until the canvass when it's determined that they already submitted a ballot.
But my point is, if someone claims that they sent a that they never submitted a mail-in ballot, right? Especially when you're talking about we have mail-in ballots in perpetuity and things of that nature. If someone makes that claim, and now their ballot's been canvassed, and they show up on election day to vote saying, I've never sent a mail-in ballot in, but now you're saying I voted. Now, their only recourse is to refer to AG. The ballot's been canvassed, even though it's been, their only recourse is to refer the matter to the AG for investigation, but the ballot's going to be canvassed and counted even if the individual states they have not voted by mail. So now, if someone legitimately has not mailed in a ballot, but a ballot arrived in their name for whatever reason, accidentally, deliberately, whatever the case may be, they're now disenfranchised, inadvertently, unintentionally, but that's what's happened in this. And the hope is would potential signature verification that verifies, hey, this really was you. You can't dispute this because we verified your signature, and diffuses these situations entirely, would potentially solve those issues. I'm just asking, would you potentially be agreeable to looking at something like that?
I don't think signature verification is the answer to the scenario you're describing. I think we have a process in place to deal with that. The provisional ballot would be cast, and when the canvassing is done, if another ballot was submitted, then the provisional ballot would be rejected.
Right, but if the person's claiming the other ballot was invalid, then they're out in the cold.
So
I'm sorry, I'm going to ask
I'm sorry.
Mr. Demarinis to come up, and if you could just give your thoughts on this scenario, and if and when and how often this happens in the state of Maryland, I would appreciate that.
So I guess one of the points too is that you have an individual or a voter coming up there that says that you're claiming that they didn't vote the mail-in ballot. Well, that could be one of the cases. The other part is that they might not have thought that the mail-in ballot was received, and so the new law here talks about the first legally sufficient ballot received. So at one point here, the provisional ballot might be the first legally sufficient ballot received because the other one may have been missing or needed to be cured because it's missing a signature as well. So this kind of is always trying to default to having, I would say, the voter get their ballot counted in a quickly and timely fashion. And with the processing early and the notification early, the individual showing up at the polls should be sufficiently reduced because then they would be getting notice from the state board saying, we've received your ballot, we've processed your ballot is now being canvassed. So those processes and those notifications there should help streamline and keep the voter informed as to not worry about going to the polls and saying, oh, wait a second, I dropped this in the mailbox. Is it going to get there by election day so that it would be postmarked and then showing up and then having to vote provisionally? So I think those are a part of this overall conversation here.
But with that being said, when a mail-in ballot arrives to be canvassed, any mark on the ballot counts. Any signature would count on the ballot, correct?
If the oath is signed, yes, then the signature from the voter, whatever their signature is, as long as it's signed, it would count.
And we don't even check to see if the signature is accurate, though.
I would say we check to make sure that it is signed by the voter.
Okay. So I guess my final question is, would having, and thank you for the time, and I apologize for going so long. I very much apologize.
You are on the subcommittee, so you'll have ample
Fair
opportunity
enough.
to go into the weeds.
Fair enough. I guess my final question is, if there was such a verification alongside this, like we've seen in Florida and most notably Oregon, would it help resolve issues where an individual states they have not submitted a mail-in ballot at the ballot box when they go to vote?
Is that to me or
To you.
to the panel? Well, I don't, I think those are policy decisions. And I forgot to introduce myself, Jared Demanis, Director of Candidacy and Campaign Finance, for the record at least. Those are policy decisions that is left up to this august body and to the subcommittee to discuss and to weigh, and that the state board is there to implement said policies. So I'll leave my answer at that.
Understood. Thank you very much.
And I would just say, Delegate Griffith, to answer your question, Stan, the man here, shared information with me. 38 other states in the U.S. Virgin Islands began canvassing early. 9 states and the District of Columbia began on Election Day, but prior to when the polls close. So hopefully that answers your question. Any other questions for these individuals? Delegate Buckle, we do have one other person coming up to testify favorable with amendment, and then some folks virtually. Delegate Buckle.
Thank you, Madam Chair. I like it's sort of an omnibus bill. There's a lot of different things in it. I don't know everybody else feels, I do like counting the ballots beforehand, because I think it helps us to get a quicker result out. And regardless of where you stand on the issue of people's thoughts about, so-called election integrity, it really helps when people go to bed at night and they know what the result is. That's just human nature. It's just built in. We don't go to bed at night if you're a sports fan and be like, well, the game's got a minute and a half to play and we just froze everything at 1.5. Let's wait a couple days. Maybe they'll play that last minute and I'll figure out what the score was. Everybody likes to know what the results. So I like that part. I like the part about reporting the election results by precinct, which has been hard to do, hard to figure out where your votes are coming from or not coming from because of mail-in. But I did want to ask, just to clarify, are we giving people up to 10 days after Election Day to go through this curative process for their signature? I mean, that's what the fiscal note seems to suggest, that if you failed to correct you didn't sign it correctly, and you get notified, you get up to 10 days after Election Day to cure that.
Right, I believe that's until the final canvass. So as long as canvassing is open, there is a chance to cure, and I'll
Right, so there's a 10-day period before it gets certified, probably isn't the right election law term of art, but before they say, hey, this is the final, we're not going to count any more ballots, this is where it's at, it could be audited, for want of a better term. But we're going to let people, you could come in, it's not going to affect a gubernatorial or statewide election, but it might in local elections or single-member district elections that are down to 20, 30, 50 votes. You'd still let people basically come in on the 10th day and be like, oh yeah, thanks for contacting me, I'll correct.
Well, those are, during those 10 days, that's also a time period within which mail-in ballots could be being received, right? As long as they were postmarked by Election Day, that's part of why that 10-day period is there, right? To allow ballots to arrive.
If I was king for the day, I'd shorten that substantially, but I understand what you're saying.
So I think, yes, there is the chance for additional ballots to come in. There is the chance for ballots that were received but insufficient to be cured.
And then my last question is, it seems like I used to joke about eventually we'll get to the point where we'll let people vote by text message, but there's a provision of this that seems to suggest that you can cure your signature by texting a picture of your signature to the Board of Elections. Is that correct?
Yes, that would be under the regulations.
Thank you.
Yeah.
Any other questions for this panel? Okay, seeing none, thank you. We have Catherine Berry, and then we will move to the folks that are testifying virtually.
Good afternoon again, Madam Chair, Madam Vice Chair, and members of the committee. For the record, my name is Catherine Berry. I'm the Election Director at the Carroll County Board of Elections, and I'm also serving as the Chair of the Legislative Committee for the Maryland Association of Election Officials. We come today to offer support of this bill. This bill does allow for voters to help feel inclusive in election night results if they voted by mail. It gives more flexibility for candidates if they wish to come and attend our public canvasses that will happen prior to Election Day. And then it also provides a larger portion of the election results to be available on election night. So this bill allows us to open, duplicate, and scan the ballots beginning 8 days prior to the election. It also allows for a waiver from the local boards to go to the state board if there are not a substantial enough amount of ballots to be canvassed. So we appreciate that provision in this bill. Mayo also has been working for the last 2 election cycles to cure ballots, even though it's not codified in law. We do that to the greatest extent possible, and we work, via email, text message, and by phone to try to get a hold of voters to get their signatures and cure their ballots. We did, as Delegate Feldmark mentioned, have a suggestion for amending the bill to having a 5-day window for capturing the receipt of the ballot. In particular, it is the internet or web delivered ballots that is a more manual process when we have to plug in the receipt of that ballot. So we would appreciate an amendment to 5 business days or another agreeable number. We also just would like to bring to your attention that we did have election results by precinct this 2022 election. It was quite a lengthy process. If anyone went into an early voting center, you saw all of the ballot styles that were there in carts. But we are striving to meet all of the layers of this bill already, even though it's not codified. So if you have any questions, I'm happy to answer those. Thank you.
Thank you. Any questions for Ms. Berry? Okay, seeing none, thank you. Do we have Linda Cohen in the virtual world? Yes, Ms. Cohen. How are you?
Yeah, thank you. Madam Chair, Madam Vice Chair, and members of the committee, my name is Linda Cohen. I'm representing the League of Women Voters of Maryland today in support for House Bill 535 on early processing of ballots. Vote by mail is just one of the options that voters in Maryland have for casting their ballot. And it's remarkable in terms of how much we learned about that between the 2018 and the 2022 election. In the 2018 election, about 5% of all the ballots cast were mailed in. In 2022, about 27% of all ballots cast were mailed in. Excuse me, over 500,000 ballots. So seeing that jump from 5% to 27% is what makes House Bill 535 so timely and so important. The League supports early processing of ballots for 2 reasons. First, it helps voters by allowing an opportunity for ballot curing to start closer to the time they actually cast their ballot. So it's more proximate, that's more logical. Secondly, it helps the boards of elections get their work done. Early processing gives us the time they need to handle the added workload that comes from significantly greater volume of mailed in ballots and make sure they can meet the deadline, the legislative deadline for certifying the election. The League of Women Voters urges a favorable report on this bill, and thank you very much.
Thank you. Any questions for Ms. Cohen? Okay, thank you, Ms. Cohen. Next, Ms. Linda Dorsey Walker, go ahead, please.
Yes, thank you very much. Again, I would urge your support of House Bill 535 for many reasons, but particularly because the need to cure ballots during the process during the canvassing period is something that disproportionately impacts the minority communities. We believe that, or I believe, that the public has a right to consistency from one election period to the next. It should not be the case that a practice that is tried for the first time, utilized successfully, and has no problem is then has to be proven the next time before it can be utilized. We had the opportunity to use the practice earlier within the last 4-year cycle. We found that it was useful, successful. The public has the right to know the result of an election sooner rather than later. And because this was a practice that did work successfully, I would urge that not only relative to this practice, but other practices that were put in place during the pandemic, that we reevaluate whether we shouldn't just make it the rule that when new technology and new practices are utilized for the first time during an emergency period such as a pandemic, that we stick with them. And that goes as well for use of electronic ballot signatures, I would say so as well. So thank you very much. I urge your positive and favorable report for support for this House Bill 535. Thank you.
Thank you. Are there any questions from the committee? Okay, seeing none, thank you, Ms. Dorsey Walker. Is Mr. Daniel Broder in the waiting room?
Yes, Madam Chair, can you hear me?
Yes, I can. We cannot see your face. Can you give us 1 second?
I'm going to be off camera if that's okay.
We do require that individuals be on camera.
Can you see me?
Yes, there you go. Thank you.
Thank you so much for allowing me the opportunity to testify. I am speaking on behalf of myself. My name is Daniel Broder, and I am a resident of District 22 of the Maryland House of Delegates, and I am here to speak in favor of this very common sense piece of legislation. I am testifying today because the early tabulation, processing, curing, and other processes which these ballots need to undergo to be authenticated and counted with integrity will be greatly helpful to municipalities like Hyattsville, Maryland, where I live, which have vote by mail elections entirely and which are seeking to implement ranked choice voting. I also support this legislation because the early reporting of results will ensure that the lies and conspiracy theories that fueled the deadly coup attempt on January 6, 2021 will not be coming from our state moving forward. I urge you all to vote for this bill. Thank you.
Thank you. Any questions for Mr. Broder? Okay, seeing none, thank you. Next, we have 2 unfavorables. Deb Ray.
Hello, Madam Chair. Let's see. Can you see me yet?
Not yet. Let's.
Right.
There
Okay,
you go.
there we go. Thank you. I was supposed to testify on 441, I think it was, so I'll just send you in my written testimony on that one. On this bill, I testify unfavorable. So under Section 11 TAC 101A, the word audit is being taken out, and this bill does not address that again. It needs to be left in. And now I think you need to add in the canvassing of voter signatures as well. The public should be able to watch the board do their work through the entire process. Under 11 TAC 101H, under voter tallying, they are taking out ways to tally the vote for no reason. It can be left in. It should be left in. I do not believe ballots should be opened or counted prior to Election Day, actually prior to Election Day poll closing. So that's another reason I'm against this bill. No one should know how the voters voted before Election Day poll closes. My main concern really though is 11 TAC 303.2, where you're only accepting the first ballot received. And I think this goes to what Delegate Griffith was talking about. If somebody steals my mail and takes my absentee ballot, fills it out, and gives you all the information that leads back to them and not to me, how do I know that a vote was cast in my name? I never will until I show up to the polls and told I'm already voted. And then, so they let me vote provisional, but then you're just telling me right now my provisional's thrown out. So I do think we need security measures. And some great security measures is voter ID. I know most of you probably aren't happy to hear that. But then for absentee ballots, let's have them notarized.
That way, the voter's signature is clear as to who has done it, and it gives the AG a way to track back to who actually signed that ballot. So again, I ask for an unfavorable. Thank you.
Thank you. Are there any questions from the committee? Okay, seeing none, thank you.
Thank you.
And we had Dana Schultz, but Dana Schultz was not there. Okay, so then that concludes the testimony on House Bill 535. Moving on to House Bill 371, Delegate Attar, and you have Brett Linginger, hopefully I said that right, coming up with you, and Howard Perlow. So this is so interesting because you, sir, look like Chair Clippinger, kind of, as you were sitting back there. And it's Timothy Hutton back. Thank you. You just have doppelgangers.
Who do I look like?
You look like the gorgeous Delegate Dahlia Attar.
Thank you, Madam Chair. And with that, thank you, Madam Chair, Madam Vice Chair, and members of the BEST Committee. In 2013, the Maryland General Assembly increased the value of an indemnity mortgage that is exempt from recordation tax from $1 million to $3 million. House Bill 371 increases the amount that is exempt from the tax from $3 million to $15 million. So, what is an indemnity mortgage? A lender agrees to loan money to a borrower on two conditions. One, a third party guarantees repayment of the loan, and two, the guarantor executes a mortgage on real property to secure the guarantee. An indemnity mortgage is the instrument that manifests the pledge of the property. It is recorded to establish a lien on the property. So, why is this bill necessary? You will hear from my panel of experts in greater detail why it's necessary, but before I turn it over to them, I'd like to make 2 points. First, only 10 states have a recordation tax, and of those 10 states, some are actually just minor fees, and others are what I would call actual taxes. And very importantly, most of Maryland's surrounding states do not have any fees or taxes, so this exemption helps keep Maryland competitive. Second, real estate has gone up tremendously, so the current exemption at $3 million helps a lot less than it did in 2013 when the legislature found it necessary to increase the exemption amount to $3 million. And while real estate value has increased, the local revenue collected from this tax has also increased significantly from approximately $248 million in 2013 to $637 million in 2021. So yes, the fiscal note is correct in noting there will be a reduction in local revenue, but the revenue being collected currently is a lot more than was projected in 2013 when the exemption was increased to $3 million. I will now turn to my panel of experts who are also available to answer any questions, and I ask for a favorable report on House Bill 371. Thank you.
Madam Chair, Vice Chair, and the members of the House Ways and Means Committee, my name is Howard Perlow, and I'm the Executive Vice President of Residential Title and Escrow located in Baltimore, Maryland, in Owings Mills, Maryland. And I thank you for the time to speak to you today about House Bill 371. I've been in the real estate industry in Maryland for almost 45 years, specifically in the settlement and title business for that time. Prior to my entry in this industry 45 years ago, banks, small businesses, small home builders, and real estate developers were allowed to use a type of mortgage to borrow from savings and loans, banks, and private investors using a mortgage known as an indemnity mortgage. And this type of mortgage was not taxable by the state of Maryland with a mortgage recordation tax. In 2011, Governor O'Malley, looking for a mechanism to raise additional revenue to help fund $37 million in teacher pension funds, asked for the exclusion of indemnity mortgages at that time. In 2012 and 13, as Delegate Attar said, the legislature first increased or allowed indemnity mortgages back at $1 million, and then again the following year to $3 million based on presentations made. We're here today to ask the legislature to increase that number from $3 million to $15 million. As Delegate Attar said, only about 7 to 10 states charge a mortgage tax. Along the East Coast, only the District of Columbia and Virginia has a 0.1% tax. Some of our taxes here in the state of Maryland in our counties can go as high as 1.4%. The rest of the states along the East Coast, from Florida to Maine, have no tax at all. Many of our developers and builders, home builders, have moved their businesses to North Carolina, South Carolina, and Florida. With the increase, when the last increases were made or were passed in 2013, the amount of, thank you very much.
Thank you, Madam Chair, Madam Vice Chair, members of the committee, Brett Leininger. On behalf of Residential Title and Escrow, also in support of the bill, and thank you to Delegate Attar for sponsoring the legislation. They really covered the ground. I think, just simply put, it's an appropriate adjustment. It's been 10 years and significant increase in the revenue, but also increase in the construction costs, really to help small to medium-sized businesses and affordable housing builders. I think it's an appropriate measure. I don't think it makes sense to keep it static forever, and with that, we appreciate the opportunity to testify and urge a favorable report.
Thank you. Questions, Delegate Buckle?
Thank you. So, I mean, I knew something about IDOTs. That's what we call them. That's what I've called them, IDOT, Indemnity Deeds of Trust. But what I didn't know is the incredible amount of revenue. When you said, is that correct, Mr. Perlow, we're basically the only state, other than Virginia, that has this fairly de minimis, that taxes the fact that you borrowed money. You borrowed money and you went to the clerk's office and wanted to actually put the paperwork in to document your borrowing, and it'll be a mortgage. And we tax you on that, and hardly anyone else does. Is that accurate?
That's pretty accurate. When a businessman buys a restaurant, when a businessman opens up a health club and has to build it out, pay for the lumber, the equipment, everything that he has, he's paid a sales tax to our state. Now, if he goes to a bank to borrow under an SBA loan, there used to be a $5 million limit on SBA, it's now 7.5. He's going to have to pay, depending on the county in Maryland, it goes, like I say, from about 0.5% to as high as 1.4%. Baltimore City has about a 1.2% tax. We settled a property for T. Rowe Price about 6 months ago. They are building the new building in downtown Baltimore. To record and keep 3,000 jobs in Baltimore, to record their construction loan, it cost them almost $4.5 million to record that deed of trust.
And all of that money, and just so for my edification, none of this goes, at least from reading the fiscal note, none of this goes to the state. It all just goes to the 24 local jurisdictions.
Pretty much based on their decision of how much they want to charge for that tax. That's correct.
And just my final question, the commercial construction costs, I don't know if you have anyone else on a panel that can speak better to that, but in my line of work, where I do a lot with construction companies and banks and things of that nature, commercial construction costs, they didn't just rise just the last year and a half in sort of this inflationary spiral. They've been rising significantly for 8 to 10 to 12 years. So a project that someone wanted to do in 2013 that was a $3 million project, do you have any rough guesstimate of what that would cost? And if they wanted to do it in 2013, it was a $3 million loan. We made a decision we weren't going to impose this, which I think is just this outrageous tax. How much would that cost be 10 years later?
I would suggest if you're looking at a large building like a T. Rowe Price, I would say their costs have probably increased 30 to 40%. What I'm really focused on here is not so much for those big projects. In Chevy Chase, we did a Ritz-Carlton project, again, $500 million. They're going to continue to pay the tax that state and the counties have, set forth at the rates they do. I'm looking for the smaller guys, the guys that are building affordable housing. I sit on the Baltimore County Planning Board, and I see the limit of housing that we have in Baltimore County and throughout the state. The Sun Papers wrote an article a couple weeks ago of the shortage in housing. Cost of housing in Maryland over the last 10 years, I would say Prince George's County was selling townhouses for $300,000. They're now $500,000. The same in Anne Arundel and Baltimore County. There are some districts that still have maybe affordable, but you have workforce housing and you have elderly housing and you have a need for this housing throughout our state. And the cost for those smaller
people that might build that kind of product, as well as the business people that need to borrow from a bank. They're actually paying twice. They're paying their sales tax and all to build and operate their businesses. Then they're also paying to be able to borrow the money from the bank as well.
Thank you.
Delegate Patterson, did you still have a question?
Thank you, Madam Chair. That was my question. Thank you very much, because I'm really intrigued and very appreciative of any mechanism we can use to advance affordable housing opportunities. And so your last statement, I believe, covered that concern for us to consider. Correct? Is there anything else you'd like to add?
I would just add that once these projects are built, whether they're under $15 million, where we're looking for an exemption, versus a $100 million project, all of the counties get very substantial property tax revenues as well that they have the right to set on these new projects, whether it's housing, whether it's businesses, whether it's office buildings. So there is very substantial increases in the assessments. I did see, I think, the third of our state that was just recently reassessed were huge numbers based on the last 3 or 4 years of the pandemic, having such a great increase in values during that time.
Delegate Feldmark.
I just wanted to, I have a couple of clarifying questions. So this would raise the cap to 15 million. So only projects smaller than 15 million. Loans smaller than 15 million would qualify. It's not the first 15 million of any loan.
That's correct. That's correct.
Okay.
If there was an $80 million loan, it would be taxable on the entire
On
amount.
the entire 80. Okay. So I guess part of my question is sort of where you landed at 15, right? Or how you landed at 15 as the appropriate threshold. Is that tied to some rate on the 3 million that it was? Is that I understand the argument about sort of helping smaller businesses, but this isn't really limited to smaller businesses, because even larger businesses taking smaller loans would still qualify, I believe, if I'm understanding correctly. So just help me understand how 15 million seems like the right number.
Well, I'll use the small residential builder that might build 10 homes a year in whatever county. He goes to a bank. The bank will generally, so that it is not taxable, will only lend him $3 million. The cost of housing for that house, an individual one house, 10, 12 years ago might have been $300,000. Now it's $500,000, $600,000. So his $3 million line will not allow him to build as many homes. Some are revolving loans, some are straight loans that get paid off as they're paid. This is going to allow him to go to, I had one builder years ago, 25 years ago, had a $20 million line with a bank. It wouldn't qualify here, but the point is that he had one loan. Now they have to go to 6, 8, 10 banks to borrow $3 million each at that point. And it's very difficult, all of the paperwork and all that's involved in it, and qualifying. Again, back to businessmen, I see many of them, the SBA, and we do a lot of that business, and M&T Bank and Bank of America do a lot of that lending for business people, not real estate people, but people that are running their businesses. There is a senator that has retired that had a business that he had to borrow to build warehouses. I don't know, it ended up costing him almost $200,000. He was running his business. So that's who I'm looking out for and looking to try to give them a little bit more leeway as the costs have gone up. I think you really have to look at that the revenue 10 years ago was $230 million, $240 million, and now it's $630 million. The revenue has increased because the cost of construction and the cost of anything, look, I can tell you the cars 10 years ago were probably, $20,000, and they're now $45,000 or even higher if it is an electric car at that point. So, that's the costs that have gone up, and that's what we're trying to help those smaller people that need that help.
Okay, any other questions for this panel? Okay, I will call up and Delegate Demi Moore. You resemble Demi Moore a little bit.
Thank you, Madam Chair.
The next panel, Bob Enton, come on up, and Lori Graff, and Tom Ballantyne. Valentine? Valentine. I'll say Valentine because it's Valentine's Day. What? I don't see him here.
He's in the Senate.
Oh, okay. Well, if he comes over, we'll let him hop up.
Good afternoon, Madam Chair, Madam Vice Chair, members of the committee. I'm Lori Graff. I'm CEO of the Maryland Building Industry Association. We represent the residential building industry. And this is, I think, my first time in this committee this session. We spend a lot of time in Annapolis. We talk a lot about housing affordability. It is no secret that we have a housing affordability crisis in the state. It is a big priority of ours to make sure that there's attainable housing for everybody in the state. It's very important. This bill will help. It's going to take a lot of things to get us where we need to be. There's a lot of different tools. I testify in E&T all the time about different housing tools that we need, but this is another step in the right direction. Our National Association did a study a couple of years ago. For every $1,000 an increase in the cost of the house, it prices 2,881 Marylanders out of that house. That's significant. We have got to find ways to make housing more affordable in the state. This is just one step. As Mr. Perlow mentioned, this is for the smaller projects, the smaller builders, the 10 lots, 20 lots, those types of things. It's very important that we try to come up with tools just to make it a better place to buy and to live in Maryland. So for those reasons, we would.
Thank you, Madam Chairman, members of the committee. Robert Enton on behalf of the Maryland Building Industry Association. It just seems to me, and I was in the committee back in 2012, 2013 when this issue first came up. It just seems to me that our builders are at a significant competitive disadvantage when it comes to building affordable housing. If I'm a builder in Prince George's County, if I'm a builder in Montgomery County, maybe Southern Maryland, and I got a choice, where am I going to build houses and what's it going to cost me to build houses? Am I going to build them in Maryland or am I going to build them in Virginia? Am I going to build them in Maryland or am I going to build them in West Virginia? The cost is so significant. You can look at the numbers, and you heard them from Mr. Perlow, that have increased since we did this, 10 years ago, I guess. But it's a tremendous amount of money. I understand the counties don't want it. If I represented the counties, I'd be here saying, this is too much money. It's going to be terrible. It's going to be the end of the world for us. But I do think that we ought to take a look at this and see whether or not there isn't something we can do to reduce this equation, if you will, and increase the competitiveness of our Maryland builders. It's a significant cost that builders in other states and our surrounding states don't face. And we hear all the time about the lack of affordable housing in the state of Maryland. And we think that increasing the amount for this deduction will help to address that issue. And we really would urge the committee to take a look at this. And I know you'll come up with whatever number you think could be done, but to pass something out to address this issue. Thank you.
Thank you. Are there any questions for either of these folks? Okay, seeing none, thank you.
Thank you.
I will call Tom Ballantyne again. Okay, so now calling the unfavorables, Kevin Canale, Trevor Ashbury, Mike Covey, and then we have one person that will join us virtually.
Thank you, Madam Chair and members of the committee. Kevin Canale here on behalf of the Maryland Association of Counties. You do have my written testimony. I would like to make a few points. With all due respect to the bill sponsor, and I do appreciate the bill sponsor taking the time to hear our concerns, this is a bad bill. This is bad policy. What no one has mentioned yet is that homeowners pay the recordation tax. What they're asking for here is for IDOTs, a tricky scheme to avoid taxes by borrowing money through a third party, that they get to take a walk on these taxes. Now, if you think that that's good policy, that homeowners should pay the tax, but we should exempt these corporations and these companies from paying this tax, then that's a policy decision, but we believe it is bad policy. In addition, to shifting a greater share of the tax burden onto homeowners and away from these companies, the bill will have a negative effect on local revenues. We heard a lot of talk about affordable housing. Counties are also investing a lot of money into affordable housing projects. This takes money away from that, in addition to schools, public safety, public health, all the other things we do each and every day to serve our residents. The General Assembly in 2012, they did close this loophole. Part of the reason was because it was to help offset the costs of teacher pensions being shifted upon to counties, but also I think it was the right policy decision, right? 2013, they came back and moved it up to $3 million for this exemption, but also there was another significant win for the industry here where they also got the refinance exemption for commercial loans. Previously, that was only available to residential loans, mortgages. Now, commercial loans are also exempt from recordation tax on refinancing. So that's an important point as well. So again, typically we provide tax breaks or incentives to incentivize socially good behavior. Here, this is just asking for a tax break because someone has the resources to hire an attorney or a CPA to come up with an IDOT scheme simply for the purpose to avoid taxes. There's no other purpose for an IDOT other than to avoid taxes. So with that, we'd ask for an unfavorable report.
Thank you, Madam Chair. Thank you, members of the committee. My name is Mike Covey. I am the Director of Finance for Montgomery County, Maryland. I would just like to add to what Mr. Canale said that every state has a unique tax system. And frankly, just because other states don't use exactly this tax doesn't mean that they don't use taxes that also bring in revenues, maybe taxes that Maryland doesn't use. Specifically, Virginia uses what they call the B-poll taxes on businesses, where they tax your cars and other things on an annual basis. I get that the recordation tax is anathema to the building community, but as Kevin said, residents pay this tax also. In Montgomery County in the last 12-month period, we have had 70 transactions that were between $3 million and $15 million. Those netted on the general fund side over $4.2 million worth of revenue. That's the equivalent of 40 to 50 public school teachers, 40 police officers, 40 firefighters and EMS employees. So this is real revenue. I'd ask you to take a look at the fiscal note. The impact is really only on local governments with this bill. Thank you.
Thank you, Madam Chair, Madam Vice Chair, members of the committee. My name is Trevor Ashbury. I'm the Chief of the Division of Finance and Procurement in the Office of the County Attorney for Montgomery County. I'd like to add to what Director Covey said and just state something with respect to the law itself. In addition to substantially increasing the monetary threshold for the application of the tax, the law also retains language requiring that a series of loans that are part of the same transaction are to be treated as a single loan for purposes of determining whether the taxable threshold is reached. In practice, therefore, parties currently do and will continue to attempt to record multiple indemnity deeds with transfer, excuse me, trust, claiming that they're not a series of loans which are part of the same transaction, and thus that the monetary threshold for taxation has not been reached. This then leaves it to the tax collector to discern whether or not the loans are so related. This problem in application initially presented itself when the taxable threshold was raised to $3 million. It will also most surely do so again, and perhaps be magnified if the threshold is raised to $15 million. Tax avoidance may be further assisted, therefore, if there is no clarity given as to the interpretation of the series of loans that are part of the same transactional language. This can and perhaps should be addressed by requiring application of the standards pertaining to step transactions or some similar standard. Requiring application of some such set of standards would provide clarity and predictability to the recordation process for these transactions. In so doing, tax avoidance would likely be minimized. Needed clarity will be provided to those seeking to record indemnity deeds of trust, and the administrative burden for counties would be significantly reduced as well. While we concur that the taxability threshold should not be increased by way of this legislation, we also believe greater clarity, greater clarity should be provided to allow for uniform application of the law as it relates to the taxability of indemnity deeds of trust. Thank you.
Thank you. Are there any questions from the committee for this panel? Delegate Buckle.
Thank you, Madam Chair. So my friend, Mr. Canale from Mako, you said, and you are my friend, you know that, you said it's bad policy. Explain to me why it's good policy to tax people, whether they're homeowners, whether they're people who want to build affordable housing, whatever they are, not on their revenues, not on their profits, not on anything other than the fact that they went out and borrowed money. We're taxing them on borrowing money. The last time I checked, that I borrowed money, I have to not only pay that money back, but I have to pay a rate of interest on top of it. And then you're taxing me because I borrowed money. How is that common sense? I mean, I don't know where we came up with this many years before you and I were over here, but where does that make any sense?
Well, thank you, my friend, for the question. And I should clarify, I mean it's bad policy to give this tax break, this loophole, to certain folks, but not to homeowners.
So make it would be okay if we just eliminated the transfer tax, the recordation tax on all mortgages, which would be a heck of a lot more money.
Sure, I don't think we'd be able to play for the blueprint, right? I mean, you'd have to come up with different ways to raise revenue, and like Mr. Covey said, different states use different methods to raise revenue. This is the one that Maryland has chosen, and so if we can come up with a different scheme, fine, but we should treat everyone the same, and that's the bottom line.
So that's a question about the gentleman from Montgomery County. I'm sorry, I didn't write your name down and went through. I didn't mean to do that. You said that, what was the time period over which you had these projects between 3 to 15 million that generated 4.2, what generated 4.2 million?
Yeah, just calendar 22.
So in the calendar 2022 year, according to the Washington Post, I looked up on my little Google machine, your county's budget was $6.3 billion. And so I went to law school to avoid math. But my quick calculation suggests that 4.2 million is less than 1/10% of your $6.3 billion in revenues. Is that correct?
Yes, it is correct.
So you're saying that you can't live without this 4.2 million from Montgomery County when you're spending $6.3 billion?
No, I'm saying that you are forcing a cut on local governments that is going to cost us at least $4.2 million in the first year, the equivalent of dozens of teachers, firefighters, whatnot. I mean, it's a tax cut. It's a mandated change in local government finances.
And you think it'll have that kind of effect that you'll have to cut teachers because you might not get 4.2 million out of a $6.3 billion revenue stream? But that's what the decision of Montgomery County will be. The first thing we're going to do is cut teachers?
We'll cut where we have to cut.
Okay.
And Delegate, I should...
We'd rather not cut because the General Assembly wanted to change this law.
Not every county has that kind of a budget either, Delegate, and that's based on 1 year's worth of data, as you know. So obviously that can fluctuate, but of course, not everybody has that kind of a budget.
I mean, my county, we don't have these kind of $3 to $15 million projects happening every day. We'd love to have the project rather than the revenue. Maybe, you know, the rich really want the revenue the most. Those of us that are struggling want to have the projects because that helps us down the road with property taxes and places for our folks to live and jobs in the construction industry. But I appreciate you guys' perspective. Thank you for coming today.
Any further questions for this panel? Okay, seeing none, thank you. Do we have Diane Fox in the waiting room? Yes, Ms. Fox, go ahead.
Good afternoon, Madam Chair, Madam Vice Chair, and members of the committee. Thank you for allowing me to testify on House Bill 8371. As the Director of Treasury of the Finance Division in Frederick County, I urge the committee to give House Bill 371 an unfavorable report. The purpose of the bill is to alter the threshold amount for certain indemnity mortgage transactions by increasing the threshold from 3 million to 15 million, as we've been talking about. This bill will provide exemptions to previously taxed documents and will have an unfair and broad negative revenue impact in Frederick County and in other counties. The indemnity mortgage is simply a loophole used to avoid recordation tax by borrowing money through a third party that is formed just for that purpose. This loophole was closed by the 2012 General Assembly. At the same time, the state required counties to begin paying the cost of teacher pensions, and the revenue generated from removing the IDOT exemption was part of the offset that helped the counties fund the cost. Reversing that action, while not adjusting local government expenditures, will create significant budget challenges for counties. Thank you for your consideration of House Bill 371. On behalf of Frederick County government, I urge an unfavorable report.
Thank you. Are there any questions for Ms. Fox? Okay, seeing none, thank you. I'm going to call Tom Ballantyne one more time. Come on up, sir. Folks, we're switching back to supportive of the legislation.
I appreciate the consideration. I'm sorry I was in the Senate. My name's Tom Ballantyne. We're representing NIOP Maryland. We're a commercial real estate trade association. Our members finance construction projects with indemnity mortgages. It's been portrayed as a loophole. I think it's a policy decision. Those construction projects that our members undertake create immediate revenues through jobs, but they also increase the value of the buildings that are being either constructed or improved, which funnels back in to local government revenues. The cost is a first cost. It's a tax on the access to capital, which is an impediment to getting some of these jobs done and something that should be removed. It's increasing the exemption amount is happening after a period of time when commercial real estate assessments increased dramatically, as did revenues from recordation tax. So I'm expecting that those points have already been made. So I'll just thank you very much for calling on me, and happy to answer any questions if I can.
Committee, are there any questions? Okay, thank you. Seeing none, thank you for coming over. And that concludes the testimony on House Bill 371. Calling House Bill 509, Delegate Tomlinson. Come on up.
Thank you, Madam Chair, Madam Vice Chair, and honorable members of the Ways and Means Committee. For the record, my name is Delegate Chris Tomlinson, and I'm testifying on House Bill 509. The Maryland State Board of Elections has a wonderful website that I'm sure all of you are very familiar with. On the website, you can easily view primary and general election results going back to the 1980s. On there, you can find the election results of all federal races, state races, including our own election results, as well as county races. However, on that website, you cannot find the election results of the majority of municipal elections. There are 157 municipalities in the state of Maryland, some large, some small, some urban, some rural. And at any given time, there are dozens of elections taking place each and every year for council members, aldermen, mayors, and even a burgess. Unfortunately, it is not easy to find past municipal election results. For the most part, an individual has to search a local newspaper's online archives to find past results, but this is getting more and more difficult as local newspapers shut down, get bought out, or put up paywalls. Some municipalities put up their election results online, but typically after they have their next election, you can't find those results, the past results anymore. So what I'm proposing is that there needs to be a central online database or a hub for the voters of Maryland to find past municipal election results. I've been working hand in hand with both the Maryland Municipal League and the State Board of Elections to fine-tune this bill and to find a solution that all parties can be happy about. On your floor system, you should be able to see that there has been a First and Second Amendment filed. Both came as a result of working with the Maryland Municipal League and the State Board of Elections. So what this bill will do is it will require that within 30 days after the election results are certified, a municipality must email over an electronic copy of the election results to the State Board of Elections. And these results will include the names of the candidates, the party affiliations of each candidate, only if the municipality holds partisan elections, which to my knowledge, there's only 3 that do. If you do not have a partisan election, you will not see the party affiliation, obviously. And then it will show how many votes each candidate got for early voting, mail-in, provisional, if applicable, and then obviously election day and the total, as well as if there was any municipal ballot questions. And this would apply to both primaries and general elections. And once again, to my knowledge, there are 5 municipalities that hold primaries and generals. So instead of requiring the State Board of Elections to create an online portal, as you might see on the current draft of the bill or the fiscal and policy note, I've worked with them and we've come to the conclusion that it would be much easier and better and much cheaper, by the way. Actually, the fiscal note currently says there's I think about 84,000. When FY '24 would cost the state, this will no longer cost anything. So the State Board of Elections would like the results just to be emailed over to them, and they will publish the results on their website, where they'll be organized by year and by municipality. So I believe that all voters, community members, elected officials, and potential candidates should be able to view past election results for municipalities, and this bill would make that possible. I'm happy to answer any questions that the committee has, and I look forward to a favorable report. Thank you, Madam Chair, Madam Vice Chair, and the honorable members of the Ways and Means Committee.
What happened to our good friend, State's Attorney?
I feel like a kid who got left after baseball practice, and his dad never came to get him.
Oh,
He's over in I think JPR.
Oh, he'll be there a while.
Yeah, I think he's actually about to testify finally right now, just the way it worked out.
Okay, all right, Madam Vice Chair.
Thank you, Delegate, for this bill. I think this is something that's certainly worthy of consideration in terms of transparency, and I appreciate you working with your stakeholders to make sure that their concerns were addressed. I was just wondering if, to the best of your knowledge, with the amendments that you've submitted, if there are any outstanding concerns from MML and SBE.
No, so actually, originally I came, I spoke to this to MML months ago and had kind of a larger, bigger idea, and they went back to their folks, came back and told me, they're not too big on, this part and this part, so brought it, scaled it down a little bit, and then after the bill was actually drafted, they came back and their one, which you'll see, I believe they submitted a favorable with an amendment, which is to, instead of being required to report the results after 30 days after the election, it's 30 days after they certify the results. And that has been handled via Amendment 1 to the bill. And then you also asked about Board of Elections. I was able to work with them. They did not want to create an online portal of some sorts. They just asked if the results would just be emailed over, and they will put them up, and that's what Amendment 2 does.
Just one thing, I'm looking for the amendment, but just in case, if you could just email it directly to my office. I'm not sure that I see it yet.
Okay, either one?
Both.
Okay.
Could you actually just send them to the committee and we'll get them out, because I don't think that I don't have them, and our analyst Stan doesn't have them.
Okay.
Okay.
Yep.
Delegate Hornberger.
Thank you, Madam Chair, and thank you, Delegate, for bringing this bill. So you mentioned that there are already some, and so this practice is already taking place for some municipalities. Is that 5? Is it 100?
Yes, thank you for the question. I appreciate it. So there's 157 municipalities, and currently there are only 3 municipalities whose results are posted on the State Board of Elections website. That's Baltimore City, Cumberland, and Hagerstown are the only 3 whose results you can find. So the other 154, you're kind of on your own.
Okay, and then a follow-up question, if I may. We have some smaller municipalities in Cecil County, and oftentimes will struggle to get folks just to run. More often than not, these are uncontested. Would this sort of transparency, just add to the ability for folks to see what's going on and possibly think about running if they've got a better handle on who's doing what and where?
That's kind of the plan. I would hope that this would inspire and motivate people to want to run. I know that talking with both representative from the State Board of Elections and Miss Berry, who is here representing, she's the director of my county's Board of Elections. I know she's gotten more people reaching out this year asking questions about municipal elections than ever before. So I hope that people are paying more attention to municipal elections and do want to get more involved, and I hope that this bill would help push us in that direction.
All right. Thank you. Thank you, Madam Chair.
Any other questions from the committee? Okay, seeing none, thank you. That concludes the testimony on House Bill 509. Delegate Crosby, Mr. Vice Chair. come on down.
How you doing, Madam Chair?
And you have a lot of folks signed up to testify, so if you want to bring somebody up now, otherwise I'll, Mr. Willie Flowers, HOCO represent.
And if it's okay, I'd like to bring up Julie Randall, who's the
Yes.
president of the local DCC.
Okay, and then whenever you're ready.
All right, thank you, Madam Chair, Madam Vice Chair, members of the committee. For the record, Delegate Brian Crosby here to present House Bill 447 entitled Local Elections, County Commissioner District Voting. Frankly, people should have the ability to elect who represents them and advocates them at every level of government, especially at local government. The bill is simple. All it says is that in county commission form of government, if you have districts, the votes have to come from that district. Many of you are probably not familiar with this because you come from city or county councils, so in Prince George's or Howard or Montgomery. For the most part, all of you have districts, and whoever represents District 1, their votes come from District 1. They don't come from a county at large. Doesn't mean you don't have a county executive or maybe a seat at large, but those specific district representatives, the votes come from that district. And the bill really gets at two things. One is accountability. You're accountable to the voters who send you to whatever form of government, whatever council or Annapolis, to the people who picked you to represent them. And the second is to, it's a bulwark against voter dilution. And voters should have a say in who will represent them on the Board of County Commissioners without their voices being drowned out by the rest of the county. And the at-large system leaves voters without a true advocate for the community's unique needs because commissioners have to appeal to the entire county in order to win their election. And so you can live in a certain district, but the bulk of your voters come from outside that district. To make an analogy, Virginians do not pick the governor of Maryland, and that is essentially what is happening. With 50% plus one vote, you get 100% of the votes at the Board of County Commissioners, currently in my district as well as 3 others. So the second thing, and I think is important, is I think that this makes campaigning a lot easier because, frankly, if you're running in a district, it's a lot easier to control that race. It's a much smaller district, and it is advantageous for somebody maybe of lesser means to just simply have to campaign in their district rather than a county that could potentially take 2 hours to drive from one end of it to another section of it. And I have heard countless times from members in my community that they do not run for office because, frankly, A, they know the outcome before they start, and B, it takes a lot to run county-wide when they don't have the means to necessarily get all the way up to certain sections of the county. I believe that this bill creates more fair representation in local government, and it allows elected candidates who represent their district without interference of voters who do not live in their district and do not share their same interests or priorities. Voters should have the ability to elect representatives who will advocate on behalf of their resources, as I said from the start. With my testimony, I included a graphic. It has red and yellow dots that can show this. But with that, I respectfully ask for a favorable report.
Good afternoon, Madam Chair. Good afternoon, Madam Chair, everybody, members of the committee. It's certainly a pleasure to be here to testify on this bill and look for a favorable report on House Bill 447. The committee did it last year, I think, and I think it's the right thing to do now. And it's really just about justice. As you well know, Madam Chair, you've done work in this space. It's about justice. It's about giving people the opportunity to vote and to have some representation in their district. And when you have these at-large elections, individuals are shut out from the elections, as explained earlier, the momentum to be even interested in an election is reduced. So that affects everything else. But more importantly, it is a significant justice issue. A lot of the Voting Rights Act's details of the Voting Rights Act go back to having single-member districts so that individuals can be represented, and you can have direct contact with your elected official, and you can feel like your vote matters, and that's extremely important. I'm here on behalf of the NAACP to, I don't have to remind everybody here, but I do want to reinforce that it's important that we keep these types of bills and these types of concerns about justice in elections at the forefront so that we can always have accountability as it pertains to government, and our citizens can feel like their votes matter. So my name is Willie Flowers, and I'm with the Maryland NAACP Maryland State Conference.
Good afternoon. Good afternoon, Madam Chair and honorable members of the Ways and Means Committee. I am Julie Randall from St. Mary's County. I'm testifying in support of House Bill 447. First and foremost, I believe that by-district voting ensures representation and accountability in local government. Each district has a representative who is accountable to the local community and understands the specific needs and concerns of those constituents. Opponents say that in-district voting of county commissioners will ignore the overall good of the county, instead just supporting endeavors of direct benefit to their district. So essentially, being elected by your community means that one is unable to walk and chew gum at the same time. That is ridiculous. It's exactly the same as suggesting that state delegates are unable to consider the good of the entire state of Maryland, instead only focusing on bringing home the bacon to their districts. The demographics of our county, like many others, are varied by location. Each location deserves the ability to elect a representative that can represent their needs and their community. In 2 districts with the highest concentration of citizens living below the poverty line, the elected officials for these districts were strongest electorally in districts other than those they were supposed to be representing. Thus, the highest concentrations of their votes came from districts other than the one commissioner candidate was running to represent. I know that traditionally considerable deference is given to the positions of incumbent commissioners and local delegations on matters such as this. Generally, I would respect that tradition. But maintaining at-large voting as the only form of voting is simply outdated and ethically wrong. The result of this bill would mean that at least some of the commissioner board would be elected by the majority of the votes in that district. Generally, I would respect that tradition. But I'm sorry, I didn't.
That's fine. We had some feedback. I don't know if somebody was in the waiting room. Ma'am, can you go ahead and wrap up? That's fine.
Oh, yes, thank you very much. Every area should be allowed at least one leader who has the voters' best interests in mind because his or her votes depend on it. I implore you, please bring St. Mary's County elections into the 21st century and vote yes on House Bill 447. Thank you very much.
Thank you. Questions? Delegate Buckle.
Thank you. So, Delegate Crosby, we've had the bill before, and all of the presentation, most of the presentation is typically about one county. It's about St. Mary's County. But the bill, as written, do you know how many counties it would apply to?
Technically 9, but it would really only impact 4.
And what are those, St. Mary's?
Well, the ones that it would impact are St. Mary's, Calvert, Queen Anne's, and Garrett. The other 5...
already do it different.
Well, they were either mandated by a court order or they did it themselves.
So I guess my question is there anything that prohibits counties, to my knowledge there isn't, to just electing all their county commissioners at large for the whole county? That's how my county does it. That's how Washington County does it. Garrett County to our west, they could just choose to come in and say, we just elect them all. They have 3 county commissioners. You just get elected top 3 countywide. your bill wouldn't prevent St. Mary's County from changing that, right?
Correct.
So would there be a remedy then? I mean, that's my concern is whatever problem exists, it tends to seem to exist in St. Mary's County, but yet the bill applies in like Garrett County. So would you be amenable to Garrett County just being exempted out of the bill?
I mean, if Garrett County wants to change how their elections are brought forward, then they can bring a bill forward after this. I do think, though, that having talked to stakeholders across the state, even in counties where this has already changed because of court orders which found discrimination behind it, I think that there are many people who would like to see this, A, changed, or B, at least codified even after they've made the change.
Which county was it that you're saying there was changed because there was a court order that found a discrimination?
I believe it's Dorchester, and I'll confirm, but I think Worcester as well. And I think the case was in the the early 1980s.
Okay, so it was a long time ago.
It was, and I mean, this might sound crazy, but I just remember seeing former Delegate Mounts take pictures in the celebration that they have every year, and that's how he ended up finding the case. So I think if you actually search his name, it comes up.
Okay. And so I guess my final question is the bill, all of the St. Mary's, I don't know all, but many of the St. Mary's County Commissioners, the Queen Anne's County Commissioners, the local governments of at least 2 of the 3 counties, 2 of the 4, and I know for a fact Garrett, I don't represent Garrett, but I'm the closest that we've got here. They're all against this.
Right.
So none of them want to do this as a local, this isn't a local St. Mary's bill. Is there my understanding that there is a local St. Mary's delegation bill to put this on referendum for the voters of your county to decide how they want it to be?
There is, but that's a paradoxical question. You're going to ask the same question for a result that we already know that basically has the same exact system. I would push back and say, should we have a referendum statewide so that state delegates can live in a district, but the votes come from all of Maryland?
That might be interesting.
It wouldn't be interesting for you.
I'm just suggesting to you. No, it might be very, very interesting.
Yeah.
I think there'd be a lot of different people that got elected here than who thinks they would get elected here. But I guess my concern is, I understand what you're trying to do. I guess my concern is when you have a county, St. Mary's County, Queen Anne's County, I'm sure Garrett County, that says we don't want to do this. Or you have St. Mary's and Queen Anne's say that in 2016 they did a voter referendum. They let the voters of their county decide how they wanted to have their county elections, and they rejected this method. And St. Mary's County, my understanding is your delegation is saying, let's do the same thing. Let's let the voters decide by referendum how we're going to do it. Why is it that we should step in? I mean, if there is a Civil Rights, Voting Rights Act violation, as you've indicated, maybe it was found in some of the Eastern Shore counties 30, 40 years ago, St. Mary's County has many fine attorneys, and the NAACP of Maryland has many fine attorneys. And it would seem to me it would be very easy for them to get the same kind of court order that would then mandate it, as opposed to the state, Annapolis, telling Leonardtown what maybe Leonardtown doesn't want to do.
Well, first off, I think that it's much bigger than just discrimination in certain cases, right? It's like, yeah, maybe we could find an attorney and to bring forward that case. In order to do that and have standing to get granted a court case, you would have to run a candidate multiple times. And frankly, it is difficult to find candidates because they are well aware of the system and they know the outcome before the election even takes place. So there are plenty of people who I think would run in district but won't run countywide because they know the outcome, and they're not just going to go through this method multiple times in order to then go through a very lengthy and expensive court case. I also would say that putting it to a referendum, again, is asking the very same question you ask during the election. Like, you're literally asking people to vote, I mean, on an outcome that you already know is going to exist on a system that benefits the majority of people. And just because 50% plus one vote gets you 100% of the elected representation on a board, I would argue that that is not necessarily fair, especially if the split isn't as far as that.
But to answer your question, there is more than one front, and the civil rights case is a significant front, and it would settle this. Because the conversation is not about politics, it's about representation. And when you have an increased number of African Americans in one county and they're not being represented, that's the civil rights case, open and shut. So you're right.
Thank you for your perspective. I appreciate it. I will always hold the position. I don't want to cramp things to counties that don't want it. Garrett County is very, very different than St. Mary's or even Queen Anne's. I think, to be honest, the African-American population of Garrett County is like 1%.
I think it's less.
Their system has nothing to do with these issues of lack of representation. It's just the way that they want to do it. And I hate to have them included in something that would make them do that. But I appreciate your thoughts on it, definitely.
Delegate Hornberger.
Thank you, Madam Chair. So my question is, let's suppose for a minute that everything that you've presented is accurate and in the best interest of the state and these counties that are impacted, and we pass this bill. My question is for charter counties that do the same exact thing, you're not applying what you believe to be is the right way to them. So if this is in fact good for the goose, why is it not good for the counties that have charter that elected at large, i.e. Cecil?
Because my understanding, and I think Cecil County came up last time on this, is that Charter County, it came with that form. Now, if it doesn't, I'm happy to include it, and we'll make that amendment. Because if that's what truly it comes down to, then sure, I'll draft the amendment and make sure we pull all the Charter County into it. But I'll follow up on that.
Okay, thank you.
I think Stan has an answer for you.
It's actually, sorry, I'm not used to talking in this gathering. I just listen. But yeah, it's actually in the state constitution that charter counties have the ability to make this choice if they want to, and so you couldn't make this mandatory statewide for charter counties without amending the constitution.
So it sounds like your bar is a little bit higher if you weighed in on charter counties. Okay, thank you for that clarification.
I think it would only impact Cecil, right?
I think that's accurate.
So, I mean, I'll go find the votes.
Shots fired. Madam Vice Chair.
Thank you so much, Madam Chair. And, you know, for members that are new to the committee, we did pass this legislation in the House 2 years ago, I believe, and it was quite spirited debate on the House floor. I think the line of questioning was very interesting, but I want to get back to the core of the bill, and that is a basic democratic right. And let me know if I'm correct about your intent of this bill, that this bill ensures that in-district voting is actually in-district voting.
Correct. That's it.
Where these jurisdictions have a system of voting, these counties have a system of voting that is called in-district, a district representative, correct?
Correct.
However, currently, everyone across the county can vote, including people who are not residents of that district.
Correct.
And so it seems that that tends to dilute the votes and cause a lack of accountability when it comes to who is representing those individuals.
Yeah, and it's no different than us, right? We get sent up here to represent districts, and you know, I still think we're able to see the broader picture, but we still are responsible and accountable to the people who sent us up here.
Thank you for answering those questions. I think something else that really strikes me is that this conversation and this feedback that, well, the counties just don't want to do it. We should just let them do what it is that they want to do and run their elections and their jurisdictions and their at-large versus in-district the way that they want to. Whenever I hear that argument in the context of voting rights, and this question is for Mr. Flowers with the NAACP, whenever I hear this argument around just let the locals handle voting how they want to handle it, especially when we're talking about representation, it certainly recalls for me the history of voting rights in our country and why we've had to step in oftentimes across the country, nationally, federal government, and the courts in terms of ensuring fair representation. So I just wanted you to comment on that in that context.
No, without a doubt. And that was my reference to the Voting Rights Act. And I guess we have short memories on this committee when it's the case that you would refer to, I don't care where the jurisdiction is, if it's Garrett County or Somerset County. If you refer back to them and allow local people to determine what is a federal law, then we have a problem. And that's why my reference to the concern about the Voting Rights Act and that representation was presented. Because if you try this case, every one of these jurisdictions that have at-large elections will be overturned. There will be districts, and there will be minority districts created. And that's that should be the goal of any voting rights case. So that's just consistent with what is going on in the rest of the country, where a case has been tried. And there are plenty of precedents for this. So I agree with what was stated earlier, and I also agree that the legislative route is just one route. And if you want to take it to the federal court, that can happen too.
Delegate Patterson.
Thank you, Madam Chair, and thank you, Delegate Crosby, for presenting this bill again. Last year, Charles County was part of the counties, because we're home rule, that was involved in the legislation as well. It was a decision of the Charles County Commissioners to adopt this, and so currently Charles County is district-wide, per district. My question has to do with this proposed structure for St. Mary's County, and that is, in our county, you would have the president being at large, and then the 4 districts. Is that the structure that is being proposed for St. Mary's County? And I clearly understand why this bill is being proposed and the need to have diversity in representation.
So just to clarify, Delegate Patterson, it doesn't change anything to anyone's structure. So St. Mary's will remain just like Charles, in the sense that we will have one county commissioner president who will run countywide, as well as the 4 districts. The only difference is now, like Charles has already adopted unilaterally, our districts, the votes will then just simply come from the district. And the reason that St. Mary's and some of these other counties who are also in favor of the bill support it is, we have to come here because we do not have code home. So we need to ask Annapolis for permission.
Thank you very much.
Delegate Buckle.
Waste too much time on this. But Mr. Flowers, when you said that if there's a court case, every county in the state will be forced to do this.
No.
Okay, we're just
you're misunderstanding what my statement.
Garrett County does not have a significant enough minority population in any way, shape, or form to create a minority district. They just don't. Whether you like it, don't like it, that's a fact. And so that's my only concern, is a remedy that may be or may not be necessary to combat a civil rights issue in St. Mary's, because that's what it is. There's no constitutional right to vote by districts or vote by group, because my county, we don't have districts. We have 3 people, you run the whole county. And it's a little bit smaller, but not that much smaller than St. Mary's County. We only have 3, you have 5. Our commissioners certainly represent more people than what your commissioners do. And so that's the only point I'm trying to get across, is there has to be some evidence that there's a discriminatory impact, if not intent. And if that's what you're suggesting, is that the system in St. Mary's County has produced a discriminatory impact, I'd like to see that just get addressed for St. Mary's County,
I don't
as
know.
opposed to throwing Garrett County into the mix.
I'm sorry that you took it there. But what I will say is this: if consistent with any interest in having a district, you mentioned that you're from Garrett County. Allegheny County.
We don't have districts.
And you're saying you don't have districts.
We don't. Neither does Washington. It's well larger than your county. They just elect them all 5.
So what the conflict there? I'm sorry. What's your name?
Buckle.
Buckle. I'm sorry. I'm gonna make a joke about buckle down, but I will say this.
I like to think that's good. It's time to buckle up. That's what we say when it gets time in here.
Well, today is my day. My name is Willie Flowers, and it's Valentine's Day. How many people got flowers? So what I will say to that is, in your scenario, and this is a significant conversation, because for many reasons. I'll talk to you later about that. Sure. But in this scenario, where you have at-large races where anybody can run, you could have 2 or 3 people. You mentioned 3 people at large?
We have 3. Yep.
What if you had 3 people who live on the same block?
We've had 3 people who've lived within
and I'm
3
saying,
blocks of each other.
And I'm saying that's unconstitutional, and it should never be that way.
I would
And
disagree with
that's
you.
what arises when we're talking about having districts, and you should feel it the same way, because residents on the other side of town don't have the support that they need and access that they need by the voters. So
I'm not wasting everybody's time with an argument. I would just say that where you live geographically is not a protected class under the United States Constitution. Your race is, but not where you live geographically.
I agree with you.
Correct, it's not, Delegate, but what I would say is, I know people and everyone wants to get charged around that one portion of at-large voting, and there are plenty of instances and cases historically here in Maryland and throughout the country where there have been discriminatory cases found in favor, or cases that were found in favor of discrimination because of the at-large system. But I think that if you just remove that for a second, I would say that each district has its own unique needs, whether that is some districts may be wealthier than other districts. Some districts may have the need for more transportation than other districts, or infrastructure projects differ between them. And so all we're saying is simply that if you represent that district, then the vote's got to come from that district, because you're representing that specific area and sent there to advocate on their behalf, regardless of how anybody looks or whatever other factor you want to use.
Thank you. I appreciate it.
Thank you.
Any other questions for this panel? All right, seeing none, thank you so much, Delegate, for bringing this bill. This panel is dismissed. Thank you. We will now call up Miriam Klapka and Jessica Jolly. You don't wish to testify anymore? Okay, what's your name? Okay, thank you so much for coming. Jessica Jolly, and I think that will be it for our in-person favorable.
Thank you. Honorable members of the Committee on Ways and Means, thank you for this opportunity to testify in favor of House Bill 447. I'm Jess Jolly, a St. Mary's County voter, testifying as an individual because I believe this bill is about small d, democratic representation, not partisan Democratic or Republican advantage. House Bill 447 would change commissioner voting in St. Mary's County for the better, from at-large to by or in district. Here's why I support the change. The current system of run by district but elect at large negates the very point of districts. The change proposed in this bill increases commissioners' accountability to their home district residents. Currently, a commissioner only nominally represents a particular area and may ignore issues within the district, but popular in most of the rest of the county. This weakens accountability. Indeed, at-large voting systems can easily leave out the most affected citizens. It waters down the effectiveness of district constituents. It weakens their voices and possible compromise solutions. In St. Mary's County, for example, the at-large system may reduce the representational power of rural citizens who do not want their section of the county to be overdeveloped or industrialized by the actions of a few who do not live there. At-large voting can easily override the educational and recreational needs of communities of minorities, working-class citizens, as well as those from different concentrations of wealth and poverty. Too often the statement, "we have no problem," means we hear no problem, which actually means we pay no price for ignoring a problem. Please adopt a favorable recommendation on House Bill 447. Thank you.
Thank you, Ms. Jolly. We appreciate your testimony. Now we'll hear from the in-person unfavorables before we go to several virtual witnesses. Kevin Canali, Jerry Clark, John Hauser, and James Moran, if you're here.
Good afternoon, Madam Chairman, excuse me, members of the committee. Kevin Canali here on behalf of the Maryland Association of Counties in opposition to House Bill 447. I think a lot of the debate has already been had, and I think a lot of the arguments on both sides have been made. I'll just say that counties believe that the proper venue to remedy the situation that you've heard and the instances that you've heard in American jurisprudence is in the courts. Again, we understand the issues that have been raised, but we've also heard a lot about at-large voting, and there are counties that elect at-large. This bill does not affect them. If the desired elements of the bill are to create that representation for specific communities, there's nothing that would stop these counties from going to an at-large system. And I don't know what the next step would be for the legislature. I don't know what you do next, and that's why we feel like this needs to go to the courts. The courts need to remedy the situation, and that way we have an outcome that, again, is set in stone. Because if a county decided that right now they have the current system and they want to just go to all at-large, it doesn't remedy the situation that the issues that have been raised before you today. So with that, we'd ask for an unfavorable report. And again, we just feel like this is not the proper venue. A superior political body is not the venue. It should be at the courts.
Madam Vice Chair, members of the Ways and Means Committee, my name is John Hauser. Thank you, Delegate Crosby. I can hear myself better now. Madam Vice Chair, member of the Ways and Means Committee, my name is John Hauser. I'm the Assistant County Attorney for St. Mary's County, here to testify on behalf of the Commissioners of St. Mary's County. Thank you for the opportunity to testify on their behalf. They wish they could have been here. Unfortunately, this is one of the days where they regularly meet. When last I checked at 4:01, they were still in their budget work session. I'm being sent in their stead because the commissioners do feel strongly that their voices and that of St. Mary's County should be heard on this important testimony. As has been summarized earlier, currently St. Mary's County has a commissioner president and 4 commissioners as their local elected officials. All are elected at large. Commissioners must live in one of 4 geographically oriented counties. The reason this system was created, I believe 5 decades ago, was to ensure that there is geographic diversity among the commissioners of St. Mary's County, while leaving each commissioner responsible and accountable to each and every citizen of St. Mary's County. Currently, a citizen in Ridge, one of our southern localities, has as much claim upon his local commissioner's time as any other commissioner in the county. If HB 447 is enacted, he could go to a commissioner from any other county, make a request, ask for help, be rebuffed, be ignored, and then that commissioner would face no impunity or retribution from that specific constituent come election time. That is the ill that the current system tried to avoid and mitigate. What the commissioners believe is that if this system has to be changed, that is a decision that should be left to the people at large. The typical countian would see their elective franchise more than halved if this bill is enacted, to go from being able to cast a vote for 5 of their representatives to just 2 of them. Such a fundamental change to the basic democratic rights of all St. Mary's Countians is something that should be left, in the commissioner's view, to a referendum that, if ratified by the locality, will be enacted, but until that moment comes, should be left as is. Thank you for your time this afternoon.
Thank you so much for your testimony. I actually do have a couple questions to the county attorney, Mr. Hauser.
Yes, Madam Vice Chair.
Thank you. You mentioned that the commissioners would like to see this as a referendum. Is that something that's coming down the pike?
That's up to you all. As we know, local referenda have to be referred by the General Assembly. I am aware that Delegate Matt Morgan in HB 597 is requesting a straw poll to be asked on this exact question. It's the same language that Queen Anne's County, I believe, used in 2016 when it came up. The commissioners of St. Mary's County support that bill. They support this being sent to the voters. And whatever the voters decide, that'll be what the commissioners are prepared to abide by.
So the commissioners are advocating for a referendum in that legislation?
They are supporting HB 597. Yes, Madam Vice Chair.
Thank you so much. Mr. Canali, I think that your argument around it being left up to the courts is an interesting one. And I am wondering, though, if in the basis for a jurisdiction like St. Mary's County is around fair representation, underrepresented communities in particular, what you're basically arguing is that in order for them to get what they believe would be justice and fair representation, that they need to find an attorney, file a lawsuit, somehow come together to be able to afford all of the costs and the process that go with a lawsuit. How exactly do you expect these underrepresented groups who have grievances around fair representation would be able to get justice for themselves by going through the courts?
Thank you, Madam Vice Chair. It's a tough question, and I think what we're saying is that anytime there are issues with district drawing or any kind of issues like the ones being raised again, the proper venue has traditionally been the courts. I understand what you're saying, but I also think it is important that if you pass this bill and one of these counties decided they wanted to just go to all at large, again, I don't think you're going to get the remedy that you're looking for, and I don't know what the next step is for the General Assembly. And I think ultimately it ends up in court. And so that's what we're saying here. And again, we just don't think this is the proper venue. I respect what you're saying and I understand it. It's a tough issue.
All right, thank you so much for answering my question. Mr. Moran, have you testified?
Not yet.
Oh, I'm sorry. Go ahead, please.
Okay, my name is Madam Vice Chair Wilkins and members of the Ways and Means. My name is Jim Moran. I am the at-large commissioner in Queen Anne's County, and I've held that position for 10 years. I was at the same hearings 2 years ago when this bill was brought up originally. Queen Anne's County did do a straw poll in 2016 because this became a topic of discussion in the counties. We have 4 districts and 1 at large. And in those discussions, at that time, I favored voting by district. Came back 54 to 46 in favor of voting at large, and that's why I'm here today, to support the at large. It's what our citizens voted for. And I don't know how we can marginalize voters of Queen Anne's County and say, well, you're wrong. We're going to do this a different way after they have voted. I will say that Queen Anne's County is 5.6% African American. So again, what goes on in St. Mary's County, I hope they can work that out. But painting with one brush for all these other counties doesn't work. And we've seen this time and time again, and I would ask for a unfavorable report by this committee.
Well, thank you so much to each of you for your testimony. There is another question here from Delegate Feldmark.
Thank you so much, Madam Chair. I have a couple of questions. First, regarding this, the concept of putting this to referendum. I guess my question is, if there is a concern that there is an underrepresented minority, how would that voice fare in a countywide referendum?
Oh, well, first, if I may respond, St. Mary's County's taken a bit of hits in the last few minutes, and what I want to say is that I'm not aware of a challenge being planned, being made that has ever been made in our county's history, or that, if made, would be successful with respect to the opinion that was voiced by Mr. Flowers in this seat a few minutes ago. I was counsel for our redistricting board when we went through it in 2021. The questions came up, we looked into it. Federal law has existed on the Voting Rights Act for 58 years, and the standards that have been laid down by the courts if applied to St. Mary's County would not, I think, result in a violation. Just to clear the air on that one. The African American population in St. Mary's County is roughly 13%. Now, to turn to the question of responding to how someone might fare in an... Thank you, Madam Vice Chair. Referring to how one of the voices might fare in an at-large referendum. The question has been put forward by some of the proponents of this bill that it's a matter of good and basic governance. The county commissioners take a different stand, that they think democracy is better served by leaving them accountable. St. Mary's County's entire population is 113,177. That is roughly, I think, on the level of the typical council size in Montgomery or Prince George's County. So to say that the St. Mary's County Commissioners aren't up to representing that large of people or being answerable to that body, the opposite is being proven true statewide right now. If it really is, though, if there's a genuine dispute over here of what is best, which of these two prevailing notions with our different ideas of which will better serve lower D, democracy is right, I think what the commissioners would say is that has to be put to the people. Let us advance the arguments to the people at large, see what they feel, have debates, subject ourselves to cross-examination and questioning, let the best arguments be put forth, and see where the chips fall in November. And whatever the verdict is going to be of the people, that's what the commissioners are prepared to stand by. And what they would suggest is the right thing to do in a situation like this.
I understand that. My question was, how does an underrepresented minority, if there is an underrepresented minority in the county, how does an underrepresented minority fare in a county-wide referendum?
I think if we had a situation where we did have underrepresented minorities at the levels that have been suggested and talked about by others today, that I would echo what Mr. Canale said, that their recourse, their best odds of success, where they would find success under prevailing law, if they can meet the standards, would be challenging this in court, where these actions are traditionally, I believe, brought, and where these remedies are sought, and where these ills addressed. And again, I've stated my opinion that I do not think a violation could be sustained based on the actual conditions on the ground in St. Mary's County, but if it would be, if we should assume that anything would ever happen down the line where a court would find that way, again, that is something where that is what the law says, as something that the county would and would have to abide by. But that would probably be their best recourse.
Thank you.
Any other questions for these witnesses? Delegate Miller. Oh, okay, Delegate Miller.
Okay. Thank you, Madam Chair. Okay, I'm very new at this, again, so I haven't heard all the arguments back and forth. I was trying to look up with your Board of Ed. How does, and if it's off topic, just let me know, but how does the commissioners differ from your Board of Ed? Are they the same? Are they the same districts? Because I was noticing you have some at large and some at districts. So could you explain that to me?
They are for St. Mary's County,
Yeah.
if I can take a stab. We have 3 Board of Education members. They are all elected at large, although must, similar to the way our commissioners are, reside within the districts they represent, although are voted upon by all members. In this bill's previous incarnation, in 2021, a change to the election of our Board of Education and Board of Educations across the state was sought. I do not see that language included in this year's iteration of HB 447.
Well, that was my question, because you do have so many counties that do have at-large, and so I was wondering about the correlation. If it's good for democracy and everyone, then it would make sense. So thank you for all
But
that.
that is a good point. We also elect our 5 members to their Board of Education at large, and one is an African American. So, I mean, I think that's, and it's been that way for the last 4 elections.
Thank you.
Thank you, Delegate Patterson.
Thank you, Madam Chair. Thank you very much. I have a question of the attorney for St. Mary's County. You cited, for full transparency, there is no diversity in your county commissioners, correct?
Right now, the St. Mary's County Commissioners are 5 white males.
Correct. And so you cited, I have a note that they reside in specific districts. That's correct?
That's correct.
Okay. Within the 13% of minorities who are underrepresented at the county commissioner level, within the districts that are cited, are there any that could potentially be represented by a member of an underrepresented community?
Well, I would say I think the suggestion to that is that anyone can run, we have had African American commissioners in the past, we have had African Americans and elected officials countywide in other offices in the past. The current jurisdictions that we have right now are 4 commissioner districts, none are majority-minority districts. The closest we come to in District 4 has 26.04% African American membership.
All right, but representing a county that's next door to you, I appreciate that. But what I think that what voters are looking for are persons who, in other words, African Americans don't just vote for African Americans. We vote for persons who are best qualified for the position. And so I just wanted to make sure, in terms of looking at the numbers, that there are possibilities, should the county elect to do so, to have representation, at least, for those persons who have not been represented for many, many years in St. Mary's County. Thank you.
Thank you so much, Delegate. Unless we have any additional questions, thank you so much to this panel. We especially appreciate you coming such a long way to testify. Thank you.
Thank you.
We will now move to our virtual witnesses. We have Alonzo Gaskin, Brandon Russell, and Daryl Hinman to start. You can proceed.
Good afternoon. Good afternoon, Madam Chair. My name is Alonzo Gaskin. I'm the Vice President of the St. Mary's County NAACP. The St. Mary's County branch number 7025 and the Maryland State Conference of the NAACP strongly encourage a favorable committee vote on HB 447. We are pleased that Delegate Brian Crosby, Maryland 29B, has refiled this bill to rectify this injustice happening in St. Mary's County and other counties around the state. It requires that candidates for boards of commissioners win a plurality of the votes in the district that they hope to represent. Every state and federal elected official in Maryland has to win in the district in which they are running. The people residing in the rural counties in Maryland deserve the right to have that same rule applied to their county elections. In St. Mary's County specifically, this results in the disenfranchisement of a large number of our minority voters. Votes from the rest of the county dilute the votes from their community. Section 2 of the Voting Rights Act of 1965 prohibits voting practices or procedures that result in discrimination or the abridgment of the right of the citizens to vote. This at-large voting essentially silences the voices of the largest community of minorities in St. Mary's County, Maryland. This unjust system is in place in Calvert, Garrett County, and in our own county. We stand in solidarity with the NAACP branches of those jurisdictions and within the Maryland State Conference of NAACP. We are calling for reform. Those who champion democracy and civil rights must do everything they can to strengthen it. This bill is one way the Maryland General Assembly can strengthen democracy in our state. And the fact that we are being painted with one brush right now. And of the 113,000 people in St. Mary's County,
Sir, if you could just wrap up your final sentence.
We'll do 20,000 of minority, and going to a referendum is no way going to support the needs of the people in St. Mary's County. Thank you.
Thank you, Mr. Gaskin. Brandon Russell.
Good afternoon, Vice Chair Wilkins and members of the committee. My name is Brandon Russell, and I am a resident of St. Mary's County. I come before you to lend my support for House Bill 447. The premise of this bill is simple. Voters should have the ability to directly pick their own representation. In fact, this is already true when we elect our state delegates and senators, as well as our representatives to Congress. It should be no different for our local elections. Electing our commissioners by district would empower voters and improve the process in a few distinct ways. First, it will make each individual's vote more powerful because they will be voting to directly elect their own commissioner. Currently, voters from across the county have a say in who is elected in each district, despite these districts having different needs. This prevents voters from holding their elected officials accountable. For example, If the commissioner from my district isn't properly serving the district, they can still be elected by votes from outside of my district, removing the opportunity to elect a different candidate in the future. This is not representative government. Second, voting by district will level the playing field by creating more opportunity for a wider candidate pool. As a former candidate, I can attest that it is difficult to run countywide. Not only does it make it harder to truly connect with voters and learn what their needs are, but it also makes the process more expensive. The expense involved in running countywide can be prohibitive for residents who may consider running for office, especially considering the commissioner role is billed as, quote, part-time. Finally, it's nonsensical that our commissioner districts are created and redistricted based on our population, yet the population of any given district has little to no ability to influence their own representation. One final point. HB 597, which was referenced earlier, is not a referendum, but only a poll, and includes language that the vote is advisory only. Were the vote to be in favor of voting by district, no action would actually be required to make the change. I ask for a favorable report. Thank you for your time.
Thank you so much, Mr. Russell. Daryl Hinman. All right, we currently don't see Mr. Hinman in the waiting room. Roderick Lewis, Marsha Greenberg, then Ellen Cole.
Good afternoon, Vice Chair Wilkins and members of the committee. My name is Roderick Lewis, and I'm a proud Southern Maryland resident. I currently live in Charles County, where they have recently taken steps to end at-large voting in county commissioner elections. I was a supporter of this move because the prior system did not acknowledge the diversity of thoughts and needs that different areas of the county had. By ending at-large voting, we aren't picking winners and losers. We're just creating the environment that allows all voices to be heard. I am first and foremost a champion of democracy, and I strongly, strongly believe in people's ability to elect their representatives. The current system in St. Mary's County, one that I'm very familiar with because I lived there for 8 years, has citizens working overtime for the same level of representation that many Marylanders already enjoy. In fact, now Marylanders in the county just north of them enjoys in Charles County. And that's unacceptable. It's unacceptable to continue to ask mentors of mine, elders in my community, to continue to work twice as hard to get their concerns heard at the local board of commissioners without any ability to hold them accountable at the end of the day. We can certainly do better in Maryland. We have to do better in Maryland. In closing, I just simply want to ask you all to follow Governor Moore's lead and leave no one behind with respect to voting rights. Because without voting rights, what do we really have at the end of the day? And so with that, I just simply and respectfully urge a favorable report on this bill. Thank you all very much.
Ms. Greenberg, you can begin.
Thank you. Good afternoon, Vice Chair Wilkins and distinguished members of the committee. My name is Marsha Greenberg, and I live in St. Mary's County. I speak today in support of HB 447. Having worked globally to promote women's political rights, I've seen many systems that undermine the right to vote. So I've been appalled that our local system undermines our votes. Consistently, a majority of voters within a district is outvoted by a countrywide majority. This is not only a matter of race. Let me offer an analogy. Imagine a school with 100 students, 55 boys and 45 girls, where students vote school-wide for all teachers, choosing between admired athletes like LeBron James and respected attorneys like Stacey Abrams. But suppose that while there are more girls in the English and history classes, they hear that all boys are committed to voting only for their sports heroes for all classes. Though girls excited about Abrams explained that she would be a wonderful teacher, this is the predictable outcome. When votes are cast, all 55 boys vote for athletes for each and every subject. No matter that girls are the majority in the English and history classes, school-wide, for all classes, the boys' votes prevail. Their 55 votes determine that athletes will teach all students and in all classes. And this results in negative impacts for everyone because no students benefit from teacher diversity. Just as girls who are the majority in a class ought to have the chance to decide their teacher, voters who are the majority within a district ought to be able to choose their own commissioner without being outvoted by cumulative countywide votes. It's simply wrong that one block of county voters determines the outcome in each and every district. Distinguished members of this committee, please recognize that the current system is unfair and undemocratic. I urge you to issue a favorable report on HB 447. Thank you.
Thank you. Ms. Cole?
Good afternoon, Chair, Vice Chair, and distinguished members of the committee. My name is Ellen Cole. I'm an assistant professor of environmental studies at St. Mary's College of Maryland, and I have my PhD in human geography with a focus on policies and conduct of local governments outside major urban areas and how structural racism impacts local experiences. And I'm speaking today in favor of House Bill 447 as both a St. Mary's County resident, as an expert in my field, and as a faculty member, but not a representative of St. Mary's College of Maryland. In my written testimony, I summarize a history of voter disenfranchisement, demonstrating how at-large voting represents a second-generation barrier to voting, or what some call Jim Crow 2.0. At-large voting, along with voter identification laws, racial gerrymandering, and discriminatory annexation, are a direct response to the end of the Jim Crow era, when overt techniques for voter disenfranchisement gave way to indirect structural barriers. Simply put, our democracy and community is strengthened by diversity. In my region, where 74% of the population is white, 100% of the current county commissioners are white, and there has only been one Black county commissioner. The importance of diverse and descriptive representation at the local level cannot be underestimated. District voting does not prescribe an outcome, but creates opportunities to elect someone voters believe will best represent their district's needs. Legislators must counter second-generation forms of voter disenfranchisement and histories of racial discrimination by erasing vestiges of structural racism. Requiring county commissioners to be elected by their district's constituents rather than at large is a structural step towards allowing the voices of Black, Indigenous, people of color to be heard through local representation. That step towards a more perfect union is why I'm respectfully asking for a favorable report on House Bill 447. Thank you.
Thank you. Are there any questions? Okay, thank you very much. Next, Charlene Pulias.
Yes, ma'am.
1 second, we're going to try to get your face on the screen here.
Yeah, it says that it's been stopped by you. There we go.
There you go. Whenever you're ready.
All righty. Vice Chair Wilkins and members of the committee, I'm Charlene Pulias, treasurer for the Democratic Club. Garrett County Democratic Club. I want to thank you for allowing me to testify in support of House Bill 447, which would require Maryland County Commissioners to be elected by a plurality of the vote in their own district. Currently, 83% of counties in Maryland already recognize the basic fairness of district voting over countywide voting. We feel Garrett County is out of step not only with most of Western Maryland, but with the entire state of Maryland. The practice of allowing countywide voting in multiple commissioner districts is undemocratic. Districts are created so that voters' concerns from a specific geographic area can be aggressively addressed. If the issue is in conflict with concerns from other districts, the commissioners will be restrained in their advocacy because they are beholden to voters countywide. In every case, the minority view will not be well represented because to do so would alienate other voters in the county. This current practice also limits those who could successfully run for office in Garrett County, particularly. If a candidate lacks funds to run countywide, they have no chance of winning a district seat. Simple math tells us that the cost is 2/3 less to run a district campaign than to run countywide. We have 3 districts. 2/3 less money, 2/3 less campaign materials, as well as less time, travel, and energy. In Garrett County, there are lots of civic-minded activists who cannot run countywide. This is not a bug in the system. This is the reason for the system, and I encourage your support for this worthwhile legislation. Thank you.
Thank you. Are there any questions? Okay, thank you, ma'am. Next, we have unfavorables. First, Deb Ray.
Thank you, Madam Chair. Delegates, thank you for hearing this bill today. I am a resident of St. Mary's County, so most of my comments will be about that, but does apply across the board of the counties that are being impacted. So right now, 5 county commissioners represent everyone in the county. We don't have district representatives. They represent everybody. Everybody gets to vote for them. It has been set up this way for the past 182 years. Districts are created so all 5 commissioners do not come from the same street. Candidate pool doesn't change with this bill. As far as the voting rights go, everyone has 5 votes and is represented by every commissioner. So no area of the county is underrepresented. And to say an African American has no representation is racist and offensive. Where's the evidence of Mr. Flowers' discriminatory impact? Our commissioners are very diverse. Not all of them think the same way, believe me. If you mean diverse by skin color, that too is racist and presumes they can't represent people who don't share their skin color. That is offensive. Non-Black people also vote for the best qualified person. Every commissioner represents the needs of all citizens in their county. Any citizen can go to any of the commissioners to resolve the issue. The executive branch is not like the legislative branch. We get to vote on every elected office in the executive branch at all levels. And Delegate Crosby's statement about Virginia voting in our elections is just a red herring and has no substance. Mr. Hauser was a little bit incorrect on the Board of Education. We have 5 members of the Board of Education. They are elected similar to the commissioners, 4 districts and 1 at large. Also, no hearings were held on this legislation here in the county. Mr. Crosby isn't doing this with the support of the people in the county. Thank you, and I recommend an unfavorable.
Thank you. Are there any questions? Okay, seeing none, thank you. Next,
Thank you.
Thomas McKay.
Hello?
Hi, whenever you're ready, Mr. McKay.
Thank you, Madam Chair. Distinguished members, thank you. My name is Thomas McKay. I'm a lifetime resident of St. Mary's County and former president of the Board of County Commissioners. I'm here today in opposition to Bill 447. Good intentions often lead to unintended consequences. The unintended consequence of this legislation will be to take away from 25% of the residents, both Democrat and Republican. It'll take away representation. As you know, America, we rely upon 3 separate branches of government: the executive branch, the legislative branch, and the judicial branch. The county commissioner form of government, generally to save costs, the commissioners are both the executive branch and the legislative branch. Now imagine a bill coming before you that sought to take away from 25% of Maryland residents the opportunity to vote for the governor of Maryland. This is the unintended consequences of House Bill 447. 3 commissioners elected by the voters from just 75% of the county will control the executive branch of government. The residents left out from the district that's left out will have no recourse, no say, no vote. We rely upon the executive branch of government being elected and accountable to the entire electoral body. This bill takes that away from 25% of the voters. This is a really bad bill. There are other forms of government available in which voting by district works, but not the county commissioner form of government. Do not take representation away from anyone, especially those who need it the most. Thank you.
That was impeccable timing, sir. Any questions? Okay, thank you very much. Thomas Mattingly.
Thank you, Madam Chair. My name is Thomas Mattingly. I'm a resident of Leonardtown, Maryland, and I'm a former county commissioner. And I had the privilege of serving 3 consecutive terms as commissioner from 1998 to 2010. I'm testifying in opposition to the proposed House Bill 447. I feel that the opportunity to serve as a county commissioner effectively requires that a commissioner have a broad understanding of the needs of the entire county and all of its citizens. By campaigning only in one district in order to get elected, the candidate will not have a full perspective of the needs of the county, and the commissioner will focus only on his district or her district and not have an opportunity to hear from the citizens at large and their opinions. In order to form good policy decisions, it's necessary to understand the feelings of the citizens throughout the county and that they know your positions as well. During my 12 years in office, I reached out to citizens throughout the county for opinions and used that as a guide for my decisions. A good candidate needs this kind of understanding of the voters and not just those from one small district in the county. During my 3 terms, each of the boards had members changed based on the elections, and they were of citizens' choices. And we reached out to all areas of the county to form our opinions. It worked well and has worked well for many years. If there is a desire to change the way we elect our future county commissioners, let the decision be done by the voters of St. Mary's County and not by a piece of state legislation. And thank you for the opportunity to make this presentation.
Thank you. Are there any questions? Okay, seeing none, thank you very much. Next, Francis Egan.
Hello? Can you hear me?
Yep, we can hear you. We just can't see you yet. One moment.
Okay.
There you go. Yep, whenever you're ready, ma'am.
Okay, thank you. Good afternoon. My name is Frances Egan. I live in Avenue, Maryland, and I thank you for allowing me to speak today. I'm a former county commissioner from the 4th Commission District, the district that has brought Delegate Crosby to sponsor this bill. It has been insinuated and discussed that some of the 4th District feel the way commissioners are elected now is unfair to minorities and others in the district. I would like to give a bit of history. The 4th Commission District had the first Jewish commissioner for 8+ years, the first African American commissioner for 8 years, and I lost him twice when I reigned, and the first woman to represent the 4th District. That was me. It has also been represented by small business owners, large business owners, those from the education system, farmers, etc. I believe this represents a true cross-section of our 4th District community, as well as the entire county. Further history, a similar proposal called Code, Home Rule, and Charter Government Bill was put to the voters of St. Mary's County, and most reviews suggest local voters should be allowed to vote on laws, policies, and rules that affect them. This was done in St. Mary's County, not once, not twice, but 3 times, and each time it was voted down. The voters have spoken. For you esteemed ladies and gentlemen to feel you know better than the citizens of St. Mary's County is just not right. Last but not least, budgets in St. Mary's County are not done by districts, but by needs and requirements. Taxes are not done by district. This 4th Commission District is the largest in the county by population, by employment, businesses, and etc. We're a cohesive county.
Thank you. Thank you, ma'am. Can you?
Those of us who work in St. Mary's County in the 4th District may drive to the 5th district, the 6th district, or the 7th district home.
Thank you very
Thank
much.
you very much.
Are there any questions? Okay, seeing none, thank you. Chris Corchiorino, which I know I said that wrong, so I apologize. Okay, he's not here, so now we're checking for Derek Adams. This is the last individual on this bill. Derek Adams, please go ahead.
Hello, good afternoon, Madam Chair and Ways and Means Committee, or should I say good evening now. I'm here to testify against the bill Brian Cosby has brought up to us. The bill right now it's going to split up all these little towns that are historically known to serve minority communities, such as Loveville, Maryland, where I am from. I currently do not reside in the area due to the housing issues up there. Nobody's selling houses. A lot of people are holding on to their homes. Once you set this bill going through the state, it's going to make certain houses be even more harder to compete, and it's going to create bidding wars. And Latino Americans, such as myself, will not be able to fight for some of these locations because it's going to turn certain houses a lot more competitive where people want to raise their kids in. For myself, I would wish that this committee would vote that this bill would be voted unfavorable to help out independent and Latino Americans trying to get locations in districts such as Bill, Maryland, and other rural districts. When you get all three county commissioners to listen to you, you can get a lot of stuff done. But when it's on the federal level, where it's just, you're voted by where you live, that's why major locations in Loveville, such as the Loveville Post Office, looks horrible compared to other locations where you're able to get a consensus between neighbors and come together and form a strong opinion. You can't do it when you're split up by streets that are voting on different committee members. Once again, I wish that you guys vote this favorably, and thank you for your time.
Thank you very much. Are there any questions for Mr. Adams? Okay, seeing none, thank you very much. And that concludes the testimony on House Bill 447, calling the final bill of the hour, or of the hours of the day. That is an applause, yes, because you are so amazing. That's what that was. Right.
Soak that in. All
House
right.
Bill 542, Delegate Fair, and you have a panel that is virtual. So the first person is Elizabeth Landry, and then Candace Karistan, Linda Dorsey Walker, and then there is an unfavorable. So whenever you're ready, sir.
Absolutely. And I'll first say that
And
this
you have,
is
I'm sorry, Jared Roche.
with me
Okay.
here. Yes,
Thank you for waiting all day, sir.
Thank you. Madam Chair, can I ask that we do all the favorable testimony at once to ask questions? Because there's the experts, they live overseas. And so to answer the questions, more technical questions, we'll need their testimony in there first.
Well, we'll try to get all of them up on the screen.
Thank you.
Okay, we'll see
I
what
appreciate
we
that.
can do.
And this is the third committee I've testified before, and by far my favorite today. So thank you so much, all of you. First, I would like to note that we've made a substantial amendment to this bill and removed the language around children who are born overseas voting. And so in order to see a clean copy of this, I suggest on your floor system, you can look up the Senate cross-file of the bill, SB 605. is a clean version of this bill, but there is an amendment. It has been processed. I'm not sure if it's in the floor system yet, but that will remove those requirements around allowing children from overseas who are born while the parents are residing overseas from voting. But Madam Chair, Madam Vice Chair, and esteemed members of the Ways and Means Committee, I am presenting House Bill 542, legislation that would re-enfranchise U.S. citizens and Maryland voters who reside abroad, continuing to build on the important work of the Maryland General Assembly to ensure ballot accessibility. This legislation alleviates a significant challenge faced by Maryland voters who reside abroad, be they members of the uniformed services or civilians living and working outside the country. As you can imagine, Maryland voters residing abroad depend on mail-in voting and encounter more voting barriers than stateside. HB 542 enables Maryland voters who live abroad to receive and vote a full ballot in federal, state, and local elections. Maryland law permits most voters abroad to only a federal ballot without state and local races. All Maryland citizens are impacted by decisions made at the state and local levels. For example, legislation debated by this General Assembly about the environment, family law, programs for veterans, medical insurance coverage, and tuition rates directly impact these voters. Additionally, Maryland voters abroad are conscientious of the issues at the state and local level that impact their families, friends, and loved ones. They take these into account when casting their vote from their host countries. According to the Federal Voting Assistance Program in their 2020 post-election report to Congress, the voter participation rate for all overseas voters was 8%, compared to 78% participation stateside. The Federal Voting Assistance Program notes that over half of the estimated 70% voting gap, defined as the percentage of overseas citizens who wanted or tried to vote but were unsuccessful, is due to obstacles to voting specific to people living overseas. They acknowledge that voters may have benefited from state legislative changes. HB 542 will help accomplish this. To ensure equitable participation in our United States democratic process from Maryland voters residing abroad, I urge the committee to give a favorable report for HB 542. Thank you.
Great. Hello, everyone. Madam Chair, Madam Vice Chair, members of the committee, thank you. My name is Jared Roush, and I currently serve as the Executive Director of Democrats Abroad. Partisanship aside, I'm intimately familiar with how dozens of states manage and facilitate the voting process for their uniformed and overseas civilian voters. To myself and all involved in this electoral process, voters being out of sight should not mean they're out of mind, or in this case, excluded from fully exercising their civic responsibility to vote. Personally and professionally, I support HB 542. While our organization is partisan, we facilitate nonpartisan voter registration and ballot requests, website votefromabroad.org, to ensure that every American living overseas can register to vote, request their absentee ballot, and get assistance if they need assistance doing so. Much of our voter registration outreach is nonpartisan to reach as many voters as possible, because every single voter and their vote matters. You can take the Marylander out of the state, but you can't take the state out of the Marylander. HB 542 ensures that every Maryland voter living abroad receives a full ballot with federal, state, and local races so they can exercise their right to vote at all levels of government. The future of their state and all decisions made to navigate that path forward are integral and consequential for each and every one of these citizens. Many did not have a voice in the election of representation in this General Assembly, but it is the responsibility of this body to grant that all Marylanders and U.S. citizens have this capability going forward. We urge a favorable report for HB 542. Thank you for your time, and I'm glad to take questions from the committee.
Thank you. Elizabeth Landry, please.
Chair Atterbury and committee, my name is Elizabeth Landry. Thank you for allowing me to share my story today. I'm here in support of HB 542. I live abroad in Sweden and I vote in Frederick. I was born, raised, and received my nursing degree in Salisbury. Years later, love took me to Frederick. I worked in DC and Maryland as a registered nurse until injuries forced me away from bedside care. In 2018, my partner and I made the leap and we moved abroad for their work. As it turns out, there are many Americans abroad, and I found a home in making sure they knew they could vote in our elections back home. In the 4 years since, I have learned many things, including an entirely new language and culture, and that I took my vote in Maryland elections for granted. When I received my 2020 ballot, some races I was used to voting for were not there. No Board of Education, no statewide or county initiatives. I asked why this was and was distressed to learn that many Maryland voters who vote abroad can only vote in federal offices. In 2022, I was only more devastated to not be able to vote for offices such as governor or county executive. While in Sweden, I am disenfranchised as a Marylander and a US citizen to fully vote as I did while living in Frederick. Important decisions are made at the state and local levels on issues that I care deeply about and that impact me: healthcare, education, affordable housing, and more. Please vote yes for HB 542 so that my voice as a US citizen in our government is the same, whether I live around the corner or across an ocean. Thank you for your time and consideration.
Thank you. Ms. Karastan?
Thank you, Madam Chair, Madam Vice Chair, and distinguished committee members. My name is Candace Karastan, and I'm calling in tonight from Munich, Germany. I'd like to thank you especially for allowing all of us to testify remotely and for sticking it out. I currently serve as the state party chair of Democrats Abroad, one of the Democratic Party's 57 state parties. We are the largest organization of US citizens living outside of the United States, and we represent the millions of Americans who are permanently and temporarily abroad, including many from Maryland. As my colleague Jared mentioned, at the center of our mission is ensuring that US citizens, regardless of party, can and do exercise their constitutional right to vote. That is why I'm asking you to please support House Bill 542, which would allow Maryland voters living abroad to receive a full ballot for federal, state, and local elections. Overseas voters, which include active duty military, military families, veterans, and civilians like myself, are guaranteed the right to vote in federal elections under current US law. The majority of US states afford all of their citizens abroad with the right to vote in state and local races as well. This is not the case in Maryland. In fact, on the substantial issues that this body has deliberated today, many Maryland voters abroad do not have a voice. House Bill 542 would rectify this, ensuring that Maryland citizens abroad can and do have a say in the representation at the state and local levels. Specifically, the bill foresees that ballots issued to all Maryland voters include state and local races. Being able to vote is a pillar to our democracy and both a responsibility and a privilege of being a US citizen. I'm a Pennsylvanian, so I traverse those roads of Maryland a lot, and Governor Moore's name on the new signs, along with the phrase, "Leave no one behind," really stood out. In advocating for the voting rights of Marylanders living all around the world, I am asking you to not leave your overseas voters and their rights behind. Thank you.
Thank you. Ms. Dorsey Walker, please. Oop, you're on mute, ma'am.
Thank you again for the right to testify before the Ways and Means Committee. I come before you in support of HB 509, but with one very important amendment that I'd like to offer. The bill is currently written, addresses the right of all US citizens abroad, who would include my college roommate, my relatives that are serving as missionaries abroad, and members of my family that are in the military, to participate in the voting process by registering and being able to vote. What I would like you to do is to extend it further to cover their right to participate in the ballot petition process that requires a ballot signature. That's not covered by this bill. Please add it because that's very important. We heard earlier in the previous bill about the right to determine what questions do or don't get on the referendum. That's a right that all citizens from the state of Maryland should be able to engage in. Earlier, I testified that there were processes that were tried during the pandemic that worked, that were tested and were successful. One of them was the use of an electronic digital signature in order to sign ballots. That should be a right open to all US citizens, whether they're living abroad or they're disabled or they're seniors or they're any other citizen of Maryland, to at their leisure read, consider, and sign or decide not to sign a ballot petition. Please add that to strengthen this because we need the voices of Ms. Landry, who I've met before, and others to add their strong voice to what's going on here in Maryland. So I ask Delegate if you would consider making that improvement so that we will have the electronic ballot signature that did work be able to be added as a permanent fixture.
Thank you. Committee, are there any questions for Delegate Fair or this panel? Delegate Griffith?
Thank you, Madam Chair, and thank you for bringing this bill. And as a veteran, this is an important issue for me. Myself and Delegate Lukey sponsored the bill 2 years ago to allow registration for overseas by using the military ID. With this, if you're a veteran, you can only vote in the state where it's your home of record, not your last residence. And a lot of people in the military will change their residency no matter what state they're from, like Florida, so they're avoiding sales tax. This still apply with this bill that has to be your registered home of record as a military member to be able to receive that ballot?
I think that Candace or Beth might be best to answer that exact question. I do know that it's the residence it's your last residence on record if you're non-military, but Candace, Beth, can either of you chime in?
Correct. Thank you, Delegate, for the question. That is correct. In all cases, it defaults back to where the last residence in the United States was. So if that was Maryland, again, that would apply to the members you're mentioning.
Before a military member, if you switch your residence to Florida, even if that wasn't the last place I lived, but I changed my home of record to Florida, then it defaults to Florida as an example. Is that correct?
Correct. If a voter, again, military or civilian, changes their residence, then it would be in the state that they switched it to.
Very good. Thank you very much.
Any other questions? Okay, seeing none, thank you very much. We do have one unfavorable. Is Deborah here with us virtually?
I am.
Okay, whenever you're ready.
Yes, Madam Chair, thank you. Committee members, thank you. And to the sponsor. Now that the bill has been amended, I have no opposition to this.
Oh, well, there you go.
I'll make it easy.
All right, thank you. Committee, that concludes the testimony on House Bill 542. That concludes the bill hearings for today. Enjoy your Valentines. Unless you are a subcommittee chair, we're about to have a brief meeting in the back. Brief, quickly. It'll be as long as you want to talk.